Hello and welcome to the 2010 Ohio High School Mock Trial Championship Round Competition. I'm Dan Schellenbarger of the Ohio Channel. We're coming to you from the beautiful and historic Ohio State House here in downtown Columbus. The room that we're in right now currently serves as a hearing room for the Ohio Senate, but it was originally the law library for the Supreme Court of Ohio and thereby an appropriate setting for this event. In 1901, the Supreme Court of Ohio heard cases right here in the Senate building in the room directly above us. Today, the third branch of Ohio government has its own building, the Ohio Judicial Center, just a couple of blocks away. In just a few minutes from now, two teams of students from two different Ohio high schools will argue a case before a panel of judges for which they've been preparing for several months. They've advanced through the local and regional competitions to make it here today, and the winning team will advance to the national tournament, which will take place in Philadelphia, Pennsylvania. The Ohio Center for Law-Related Education coordinates these mock trials. More than 360 teams have been competing this year to get right here. Our two teams today are on the side of the plaintiff, Indian Hill High School from Cincinnati in Hamilton County, and arguing for the defense, Sylvania's Southview High School located in Lucas County in suburban Toledo. Joining me now is Addie Natalie of the Ohio Center for Law-Related Education, and she's the coordinator for the mock trial program. Addie, thank you for joining us.
Thank you.
Before we talk about the cases that we're going to be hearing, can we talk about the mock trial program?
Yeah, the mock trial program in Ohio is the fourth largest in the nation. It is also in its 27th year in Ohio. Ohio is lucky enough to have 360 teams participate each year from around the state. Those students are of the high school age, grades 9 through 12. And each year, a mock trial case is released, an original Constitution-based case that a case committee writes. Those students use that case to present what you're going to be seeing today.
Now, I've noticed, I had a chance to look at some of the competitors, and I recognize some of the faces from last year.
Yes, the high school mock trial allows students the opportunity to participate up to 4 years, 9th, 10th, 11th, and 12th grades as they're involved in the high school grade level. And many students we see do come back time and time and again. And when we do write those cases, we take that into consideration, each year trying to focus on a different constitutional amendment. So those students who participate more than 1 year get to learn about more of the Constitution than just one specific amendment.
Now, for the students that are here today, how many times have they performed this mock trial to get here?
The students today have all participated at a district site. We have 30 district sites around the state coordinated by volunteers. At those sites, they won both a plaintiff and a defense trial. Each team does play both sides, so today we'll only be seeing each team play one side. Those students who win both plaintiff and defense then advance to the regional competition. We have 9 volunteer regional coordinators who coordinate those sites around the state. That happened in late February, and then every team that won both plaintiff and defense at regionals advanced to our state competition, which actually started on Thursday, March 11th at the Franklin County Courthouse. These teams then participated in 2 trials on Thursday, 3 trials last night lasting till about 9 or 9:30, and here we are this morning. So the 6th trial for the state competition process, but this is really their 10th trial.
Wow. So now, what kind of classes are they from? Are they taking pre-law in high school?
These students come from every background. Most of the time, these students are part of a club, a mock trial after-school program, though some schools do use the program in their regular curriculum. The Ohio High School Mock Trial Program is aligned to the state standards and correlations for grades 9 through 12 in English Language Arts and Social Studies, so we do ensure that this program can be utilized in the classroom and meet those state standards as well.
Did the students ever get back to you after they've graduated?
We do actually see students come back volunteering, and we love to see them when they are attorneys. All of our judging panel members are members of the legal profession, so they do have that background, and it always is exciting. We know people will become lawyers. We don't have the exact specifics, but I know we had a judge last night who was a mock trial participant and came back.
So, and I wanted to go over that these students actually were competing yesterday. So it was hard competition yesterday to get here today.
Hard competition yesterday. They did 3 trials yesterday. Those last about 2 hours apiece. So it's been a long road, but we are certainly glad to be here at the State House today for the final.
Well, great, and thank you very much. Let's talk now about this year's judges. This year's presiding judge is Justice Robert R. Cupp. Prior to his election to the Ohio Supreme Court, In November of 2006, Justice Cupp served on the Ohio Court of Appeals 3rd Appellate District, which comprises 17 counties in northwest and west central Ohio. Before becoming a judge, Justice Cupp served 16 years as a member of the Ohio Senate, beginning in 1985 and ending in 2000, with the advent of Ohio's legislative term limits. Before his election to the General Assembly, Justice Cupp served as a Lima County prosecutor and assistant director of law from 1976 to 1980, and twice was elected Allen County Commissioner, serving from 1981 to 1984 and 2001 to 2002. Gary Daniels is original from Youngstown, Ohio. He is the Associate Director of the ACLU of Ohio and heads the ACLU Ohio regional office here in Columbus, where he's lived since February of 2008. Mr. Daniels has worked for the ACLU for more than 10 years, from 1995 to 2000, and from 2003 to the present. Before becoming Associate Director, he worked for the ACLU of Ohio in the position of Litigation Coordinator. Mr. Daniels currently serves on the board of Ohio's Center for Law-Related Education and Community Shares of Mid-Ohio, where he is also that organization's governing committee. He's on that governing committee. Judge Mike Fain was first elected to the 2nd District Court of Appeals in 1986. Judge Fain received his BA from Yale College in 1968 and his JD from the University of Pennsylvania Law School in 1972. With American Jurisprudence Awards in Constitutional Law and International Law. Judge Fain was born in Miami, Florida in 1946 and has resided in several states while obtaining his education and during his service in the United States Navy Reserve. Judge Fain entered the general practice of law in Dayton, Ohio in 1973. He lives in Washington Township in Montgomery County. Jeff Ginsburg is a graduate of Walnut Hills High School, the University of Cincinnati, and the Vanderbilt University School of Law. He was a legal aid attorney for 6 years, a magistrate for 12 years, and is now a lawyer in private practice in Millersburg, Ohio. Mr. Ginsburg serves on the Ohio Supreme Court's Advisory Committee on Domestic Violence and is the current chair of the Ohio High School Mock Trial Competition Committee. Chris Gleerose is the first assistant attorney with the Ohio Attorney General's Office. Mr. Gleerose has been with the Ohio Attorney General's Office since January of 2009, when Attorney General Richard Cordray took office. Before joining the government, he practiced law at Joines Day, clerked for the Honorable Alanon L. Marbley, U.S. District Court Judge of Southern District, Ohio, and worked for George Stephanopoulos. Chris graduated from the Columbia University and Stanford Law School. Barbara J. Howard is the current president of the Ohio State Bar Association and an OSBA-certified family relations law specialist with collaborative law training. Ms. Howard has provided many years of service to the Ohio Bar. She has served on the OSBA Board of Governors since 2005 and previously chaired the Government Affairs Committee. She lives in Cincinnati with her husband, Mike Belmont. Judge Jerry McBride received his BA in Political Science from the University of Cincinnati in 1973 and his Master's of Public Administration from the University of Cincinnati in 1974. Mr. McBride currently serves as a judge for the Claremont County Pleas Court. He's also previously served as a judge for the Municipal Court and as a county commissioner for Claremont County. Well, those are our judges. Now let's talk a little bit more about what we're going to see here today. To help us through what we're going to be watching is Lisa Eshelman. Lisa is an attorney with the Ohio Environmental Reviews Commission. Thank you for joining us today.
My pleasure.
What case? What is the case about?
We have a very exciting First Amendment freedom of speech case before us today. The case of Alex Leslie versus the Erehwon Local School District is intended to talk with students and teach students about the limits or permissible limits of First Amendment freedom of speech. In this case, Alex Leslie is a senior at Erehwon Local High School. He created a blog using his own computer at home with all of his postings being done at home. However, the school has now alleged that those posts are causing a disruption at the school. And therefore, the constitutional question is, what are the permissible limits for a school to regulate speech that is created off of school campus? Alex Leslie will allege that it is protected First Amendment freedom of speech, and therefore the school has no right to regulate that conduct. Leslie will also say that even if the school does have the right to limit or limit that kind of free speech. What they have done in this case, which they have suspended Alex Leslie, is beyond the scope of permissible First Amendment freedom of speech. The school, on the other hand, will allege that we do have the right to regulate speech, and that the disruption caused by the blog in this case, substantially outweighed the First Amendment rights.
Now, how are these topics chosen? This seems to be a very, very topical topic.
The case committee works very hard to look at relevant types of cases, and what could be more relevant than students' use of technology and how that technology affects their everyday life. And so the case committee looked at technology broadly back in the fall when we began to look at the case, and then decided on using blogging with respect to a couple of cases that are coming up to set those limits on permissible restriction of student speech.
For us non-legal folks out there, can you describe the difference between the defense and what defense is and what a plaintiff is?
Sure. The plaintiff in this case is Alex Leslie. He is the high school senior who has been suspended from school and has brought a lawsuit against his school saying suspending me was inappropriate. The defense in this case is the actual school district, the Erehwon School District, that said we have the right to limit Alex's speech because of the disruption it caused to our school.
And then what are the judges looking for while the students are up there litigating their hearts out?
The judges are going to be looking for a broad variety of things. Most importantly, the judges will be looking at these students' abilities to follow the trial rules of procedure. How are their witnesses prepared? Are they asking the correct type of open, direct examination questions? Are they asking the right kind of cross-examinations? The other things that the judges will pay a lot of attention to and score points for are these students' knowledge of the case, including all of the facts that are relevant to the case, and how do they incorporate those facts into a consistent argument for their client's position.
Now, in every case, there's actually the rule of law, so actually what's being talked about. But then there's the presentation. How much is it with confidence in the oratory skills of the students that actually get taken into account for when the judges are doing their judging?
Because this is a high school mock trial and we emphasize the trial skills, those are the kinds of qualities that the judges will pay most attention to. These judges are not here to decide the rule of law. We are here to look at the students' command of trial procedures, command of the facts, recognizing that the case legally could come out very different.
And are there different outcomes based on the judges or on the level of arguments that do students trip up each other by not following a script, or is there anything that they can do kind of to subvert the process?
Well, there are very strict rules in terms of what students are able to do with the facts that are given. That case file has to be followed. Students are prohibited from bringing in outside facts, exaggerating on the facts that are there. Now, they can use really good legal analytical skills to make the job of the other side harder, meaning that their witnesses are better prepared, the questions are better prepared, and that they have a theory that they're using those facts to work itself into.
There's no mystery last-minute witnesses or anything like that?
No, there's not going to be no smoking gun that comes up at the last minute.
Well, great. Thank you very much.
Thank you.
We're going to have another chance to talk with Lisa again later during the judge's deliberation and to get her take on the student's performance. Joining now is Jared J. Wrights, Director of Programs for the Ohio Center for Law-Related Education. And he's going to tell us a bit about the center. How did the center get started?
Well, it started 27 years ago with this mock trial program. It started as the Ohio Mock Trial Program, so we've been going for 27 years. There were a group of people who felt students should better understand our legal system and how it works within our democracy.
And what is the goal for the center?
Well, the goal for the center is to partner with teachers to bring citizenship to life. And we have authentic activities like this where students interact with, if you will, the powers that be. They're being judged by real judges and even a member of the Supreme Court. And the other programs we bring in legislators, political science professors, so students have a one-on-one with the people who know.
For teachers that want to get involved in the program, how would they find out more information about it?
The best thing to do would be go to our website at www.oclre.org, and all of our programs are explained there, or give us a call.
So you've seen a number of these mock trials.
I have.
what are some of the highlights that you can remember? What do you think the students actually take from this experience?
Well, as a former educator, I really enjoy watching the students think on their feet. You know, when you're serving as a witness or an attorney, you have to respond to what's being said. So I really enjoy just watching those wheels turn as these students begin to figure it out, and on the spot. It's really inspiring.
Now, a big thing in education, of course, is experiential learning, where
Yes.
you're not just studying,
That's right.
you're actually doing something. So how do you think that this contributes to overall scholarship for the student?
Well, obviously, just by the fact that they're thinking critically, they have to solve problems, they have to work collaboratively. All of those things are in the standards, all of those things are 21st century skills, and those are the things the students have to do in order to prepare the trial.
In the number of cases that you've seen, in the number of these trials, what do you think are the critical components of the students that make them successful in this program?
Well, I think they're curious. I think they have a little bit of a sense of theater. That helps. And I think they like problem solving, and because our problems are current, they're very much interested in what's going on around them. And obviously technology, with this year's case, really gives them an interest.
Now, when the teams are preparing for this, how do they have coaches, or do they use a debate coach, or how do they get kind of skilled in the whole legalization or
Right.
la?
It varies from school to school, but they are required to have a legal advisor, and that legal advisor can guide them in the legal aspects. Then they have their teacher, but each team approaches it differently.
Do those legal advisors usually charge by the hour, or do you think they're pro bono?
Oh, they're pro bono, and they're more excited than the teacher, and they're the ones out in the hall walking back and forth, and they can't watch. It's really exciting for them. They really enjoy it.
Now, I've noticed that this year that there's some familiar faces from last year. Is there regions of the state that usually find themselves coming back as repeat winners, or is there upsets?
Well, there are upsets, but because there are so many, and some teams are veterans, if you will, the legal advisors, the teachers, understand the program and have good students with which to work, but we're very surprised at the upsets. But like a lot of programs, the teachers have the experience, and that helps.
Do you think that a lot of students that actually go on to be successful in the program have been here multiple times?
Some have, because they can start as freshmen or sophomores and just by observing the program. But yes, many of them have been here several times.
Do you have students get in touch with you after they've graduated?
Oh, absolutely. How can we volunteer? And did you know I'm now a lawyer, or I now am working for the State Department, and thanks for the experience that OCLRE gave them.
It's nice to know a whole bunch of future judges and attorneys, isn't it?
It's always good to know an attorney and a judge, and yes, it's nice.
So how far out do you start preparing for, like, what will be next year's topic?
Well, Addie will be meeting with the case committee probably in a month. She'll start again, and we'll come together and we'll begin to discuss, as Lisa had said, current events and what's important to students, what should they need to know, and then they'll begin to look at perhaps cases that are out there now as they begin to try to decide what do they want to do. It's fun to watch them brainstorm.
Yeah. I read the figure that it was 360
Two or three teams this year. Yes.
So what are the levels that it takes to get actually to the state competition?
They start with a district competition. After the district competition, they have to go to a regional competition. From the regional competition, they come to state. And Addie coordinates, I'm forgetting how many districts she had around the state, but there were 10, 12, maybe nearly 20. Then fewer regionals, but still a lot. And then we had 36 teams come to Columbus on Thursday.
So the districts are within the districts, and they're picking their own judges and going through that process.
We're fortunate to have coordinators who work in each of the districts, and then they find the courtrooms and the volunteers and so on, so the students can come and do their trials there.
So that is your organization is planning on who is picking the judges and
Right.
everything.
It comes from us. The direction comes from us, then the coordinators, and we're very grateful for the work that they do.
How did you get involved in the program?
How did I get involved?
Yeah.
I was a teacher for 30 years, and I did several of our programs, liked them so well, and when I retired, they asked, we have a position here, you interested? And I said, I am.
Well, great. Thank you very much,
Fine.
Jared.
Thank you.
Thank you. Well, Jared, thank you. Again, you're watching the Ohio Channel as we broadcast live from the Ohio State House for the 2010 Ohio Mock School Trial Championship round, and it looks like the proceedings are about to get underway, so we'll go right now to the main floor of the courtroom.
may be seated. Good morning. Before we begin, judging panel will introduce ourselves. I'm Justice Bob Cupp of the Supreme Court of Ohio. And now my colleagues will introduce themselves.
Jerry McBride, Judge of the Claremont County Court of Common Pleas, and I'm on the Mock Trial Competition Committee.
I'm Gary Daniels, Associate Director from the ACLU of Ohio.
Barbara Howard, President of the Ohio State Bar Association.
Chris Galeros, First Assistant Attorney General.
Jeff Ginsburg, I'm a private attorney in Millersburg and on the Competition Committee.
Mike Fain, I'm a judge of the Ohio 2nd District Court of Appeals and a member of the Competition Committee.
All right, are counsel ready for opening statements?
Yes. Yes, Your Honor.
All right. The plaintiff may proceed.
Before time begins, I'd just like to take a moment and have my team introduce ourselves. My name is Brittany Schwab, and today I'll be doing the opening statement for the plaintiff of this case, Alex Leslie. Following my opening statement, I will be doing the direct examination of plaintiff witness Dana Clark, and then the cross-examination of defense witness Professor G. Lee.
Good morning, Your Honors. My name is Danny Strunk. I'll be giving the closing argument for the plaintiff today. Before that, though, I will be doing the direct examination of plaintiff witness Alex Leslie, followed by the cross-examination of defense witness Kendall Dell.
Good morning, Your Honors. My name is Hannah Kahn, and today I will be playing Alex Leslie, the plaintiff in this case.
Good morning, Your Honors. My name is Olivia Morris. This morning I'll be playing Dana Clark.
May it please the court. Your Honor, a man's home is his castle. And we're here today because Erehwon Local School District is liable for violating this sacred privilege by extending their arm of authority into Alex Leslie's castle and restricting her speech. Alex is a senior this year at Erehwon Local School District and is currently enrolled in an advanced placement, or AP European History class, taught by Professor Lee. Alex does her best to contribute to the classroom by asking questions so that all the kids can better understand the material. But unfortunately for Alex, her AP Euro class was very difficult, and Alex and her friends were having problems understanding the material. Even more unfortunately for Alex and her classmates was that their professor, Professor Lee, refused to answer their questions and left the kids no other choice but to figure it out on their own. And so, that's exactly what Alex did. She went home and created an online website called a blog on which students could exchange notes, ask questions that went ignored in the classroom, and voice their frustration with the class. Professor Lee, however, grew very angry by the opinions that were expressed on the website and sought revenge by complaining to Principal Thompson, who shut down the internet, suspended Alex from school, and prevented her from walking at her high school graduation ceremony, claiming she caused a substantial disruption to the normal school process. Your Honor, there's only one issue that stands before the court today, and that is whether Erehwon Local School District may be held liable for violating Alex's First Amendment right to free speech. The evidence will show that the defendant did in fact violate Alex's rights, and consequently, Alex is entitled to damages for the abuse of discretion on the school's account. The well-settled law says that internet speech is protected by the First Amendment. Moreover, according to the seminal U.S. Supreme Court case Tinker v. Des Moines, speech that caused no substantial disruption to a school may not be regulated by that school's administration. Through their testimony from Kendall Dell and Professor Lee, the defendant may attempt to justify Alex's punishment. But you won't hear their witnesses give any testimony about comments that Alex made to this website during school hours or on the school campus. And that's because they don't exist. Through the testimony today, the plaintiff will prove 5 facts that indicate that Alex did not cause a substantial disruption to the high school. First, you will hear from Alex herself that the blog was created entirely off campus, and 2, that the website served an educational purpose. Then you will hear from Chair of the History Department, Dana Clark, that 3, any disruption that occurred at the school wasn't from Alex Leslie's website, but Principal Thompson's overreaction to the situation, and that 4, that overreaction to the situation led to a disproportional response in Alex's punishment, and 5, that disproportional response in Alex's punishment has already led to a chilling effect on speech at Erehwon Local School District. Your Honor, you will hear throughout the course of the trial today that Alex did use some profanity in criticizing her teacher on this website. But that doesn't mean that the school can reprimand her for her speech. Because let's be honest, who among us hasn't disagreed with a teacher? And who among us hasn't listened to a peer criticize a teacher? The evidence will show that punishing Alex for her opinions was intended to have a deterrent effect on similar students and intended to cause a chilling effect within the school. Therefore, we respectfully request that you rule in favor of the plaintiff, because at the end of the day, Your Honor, a man's home is his castle, and Alex's home should be her castle as well. Thank you.
The defense may give their opening statement.
Yes, Your Honor. Your Honors, before I begin, I would like to introduce myself as well as my team. My name is Smriti Gupta, and together with my co-counsel, Clement Dupuis, we will be representing the defense, the Erehwon School District today. We'll be calling 2 witnesses today, the first of which, Professor Grace Lee, will be played by Brianna Cry, and the second, Mr. Kendall Dell, will be played by Austin Mance. May it please the Court, the case before you involves a balancing between the responsibility of the school to provide an educational environment and the student's right to free speech. In examining the school's responsibility, it can be found that the school can restrict speech that promotes unlawful behavior or is incompatible with its basic educational mission. In this case, Principal Thompson acted appropriately when he suspended Alex Leslie for verbally abusing her teacher and inciting disorder within the classroom. Now, stepping back, in today's case, we'll be applying the principles set forth by the United States Supreme Court in the Fraser and Tinker cases. Upon these principles, 2 points will be made clear. The first, that in being directed towards the school and inciting disruption within the school, Alex's blog was susceptible to the Erehwon School District's disciplinary policy. And second, in direct violation of that policy, Alex's blog caused a substantial disruption to the normal school process, not only within Professor Lee's classroom, but within the entire school. Today, you will be shown the same evidence that was before Principal Thompson when the suspension was issued. This evidence will include a copy of Alex Leslie's blog, within which you will be able to see the profane and vulgar language with which she speaks to her fellow students. This evidence will also show, as opposing counsel mentioned in their opening statement, that Alex's blog was used for school purposes, as she posted her classroom notes, held classroom discussions, and posted her class schedule on the blog. However, this evidence will also show that by the first week of November, Alex invited her fellow students to vent on her blog as she started her own tirade against Professor Lee. Over the next 4 days, Alex went on to call her teacher an unimaginative jerk, a mad bomber, an SOB. She laced her entries with profanities and went so far as to say on November 5th, well, expletive that and expletively. However, Your Honors, Alex didn't stop there. No, on the very first blog entry that week, Alex told her fellow students to ignore Professor Lee and to take control of the classroom by creating their own lectures. Professor Lee will testify that on the heels of that blog entry, the classroom setting became chaotic. The students were not paying attention to their materials, but were rather talking about the blog. They're asking irrelevant questions, and the disruptions were getting to such a point that students were having trouble concentrating within the class. Professor Lee will also testify that she did everything in her power to control the situation. She tried to separate Alex from the group, but it didn't work. She told the other students to quiet down and pay attention, but that didn't work either. With nothing else left, Professor Lee took the blog and the problems within the class to Principal Thompson, who then conducted an investigation of the problem. As you will learn, Kendall Dell, the school's IT director, was part of that investigation, as he confirmed that the school's computer network was being utilized to access Alex Leslie's unauthorized blog. His investigation will also reveal 500 hits, over 150 hours of usage on the blog at school, as well as an email from Alex telling other students to access her blog. Those same students, Your Honors, then access Alex's blog during Professor Clark's class period, as well as other times within the school hours. It is based on this testimony that it will be clear that the substantial disruption within the school was caused by Alex's blog. Your Honors, the evidence today will show and prove the defense's points and will show that the plaintiff will not be able to carry their burden of proof. Rather, it will be shown that Alex's blog did cause a substantial disruption to the normal school process and did clearly violate the Erehwon School District's disciplinary policy. It is for these reasons that at the end of the trial, we will ask you to rule in favor of the Erehwon School District. Thank you.
This time, the bailiff will swear in the witnesses.
All parties who are to give testimony in these proceedings, please step to the front. Please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, and that it will comply with the rules of Ohio mock trial?
I do.
You may be seated.
Plaintiff may call your first witness.
Yes, Your Honor. At this time, we call the plaintiff herself, Alex Leslie, to the stand.
Good morning, Your Honor.
May I proceed, Your Honors?
You may proceed when you're ready.
Your Honor, before opposing counsel proceeds, I would just request to either be able to position myself or if opposing counsel would be able to reposition themselves so I would be able to view the witness.
I assume the witness stand is permanently affixed. What is is the lectern in the way?
The podium as well as opposing counsel themselves.
Your Honor, I have no objection to Ms. Gupta moving or sitting in another location so as to be able to see the witness or myself.
I think it's a little difficult to move the furniture around, so feel free to position yourself where you're able to observe the witness if you wish. You may proceed.
Thank you, Your Honor. Could you please state your name for the record?
My name is Alex Leslie.
What grade are you currently in high school, Alex?
I'm a senior at Erehwon High School.
Let's start from the very beginning. Do you own a computer?
Yeah, I do. Actually, for my 16th birthday, my parents got me an iMac.
Now, for those of us who aren't computer savvy, could you please elaborate on what exactly a blog is?
Well, sure. A blog is, well, it's essentially an online journal, if you want to think of it as that. You could also even think of it as sort of like a series of emails that the author posts to the website, and pretty much anyone can view them.
Now, do you blog, Alex?
Yeah, I do. I actually use my iMac to blog, and I actually blogged about Professor Lee's class later in the school year.
Let's talk a little bit about Professor Lee. How did you first become familiar with Professor Lee?
Well, the very first day of class, we walk in, and Professor Lee has us read the introductory chapter of the textbook aloud, like we were first graders instead of seniors in high school. It was ridiculous.
Let's be clear, Alex. Do you like Professor Lee?
No. To be quite honest, I don't.
What is an AP class, Alex?
Well, AP stands for Advanced Placement. It's essentially a college-level class that if you do well on the exam at the end of the year, you can actually earn college credit for.
And how was Professor Lee as a teacher?
She's horrible. I mean, she's mean and sarcastic in class, to the point where students don't even want to volunteer anymore.
Objection. Lack of personal knowledge. Ms. Leslie can't testify as to what other students do or do not want to do.
Have you heard, Your Honor?
Yes.
Ms. Leslie was present throughout the class periods that Professor Lee spoke. This is based on her perceptions pursuant to Evidence Rule 602.
Objection overruled.
Did you witness any instances in particular which demonstrated this attitude that Professor Lee cut off students.
Yes.
Could you elaborate on that for the court?
Well, one day in class, a boy in my class was talking about his sister who's working in an underprivileged country as part of a peace mission. And he was describing the conditions there and just some of the work she was doing. And we were all really interested. I mean, it's really great work. But Professor Lee just cut him off and said, you know, why don't we get back to what the school district is actually paying me to teach you?
How did Professor Lee, how does he relate or she relate to your blog, Alex?
Well, it's because I was having such difficulty with the AP European history material, and because Professor Lee was just such an impossible teacher that I started blogging about school in the first place.
Was there any incident in particular which made you want to blog about Professor Lee?
Yes.
Could you elaborate on that for the court?
Well, on a separate day in class, we were talking about some of these nuclear weapons tests that a few rogue countries had been doing. It had been in the news lately, and we were all really interested. I mean, that kind of thing doesn't happen often.
Objection, lack of personal knowledge. Again, Ms. Leslie cannot testify as to what students were interested in.
Response.
Your Honor, she was present during this discussion. This is again based on her perceptions and what she observed during the class period.
Your Honor, may I respond?
Objection will be overruled.
Please continue, Alex.
And yet again, Professor Lee just cut us off and said, you know, I don't see what the big deal is, because if any of these countries were actually a threat, the United States would just wipe them off the map. I couldn't believe she would make light of such a serious issue.
What did you do in response to Professor Lee's statement?
Well, I mean, she was essentially talking about just willy-nilly killing millions of people. So of course I challenged her.
And what happened after you challenged her?
She threatened to send me to the principal's office.
Does Professor Lee take kindly to difference of opinion?
Not from what I can see.
Let the record reflect that I'm referring to what has been previously stipulated as both Exhibits A and B. Let the record further reflect that I'm showing Mr. Dupuy unmarked copies of both exhibits. I believe your honors already have copies.
Correct.
Permission to approach the witness, Your Honor.
Granted.
Thank you, Mr. Strunk.
Alex, referring to Exhibit B, we've already defined what exactly a blog is. Could you please elaborate on what a blog entry is?
Well, you could think of a blog entry as an email, essentially. An example can be seen on page 87. The author of the blog posts it to the website, and anyone can see it.
What's the difference between a blog entry and a blog comment?
Well, if you're thinking of a blog entry as an email, then a blog comment would be sort of like a reply to that email. There are examples on page 88, Your Honors.
In her opening statement, Ms. Gupta referred to your blog as a tirade. What were the purposes of your blog entries, Alex?
Well, first of all, probably the primary purpose would be education. I mean, I would post notes, and my classmates and I would discuss AP European history and what we were learning in the class and try to clarify things for each other. And second of all, it was really a forum in which to vent about our frustrations with Professor Lee as a teacher. And thirdly, it was really just a form of speech in general, since Professor Lee cut us off so often in class.
Alex, let's put your activity on this blog into perspective. How many total posts are there to Exhibit B?
Total posts, let's see. About 30.
Of those 30, how many did you make to your blog?
I made, let's see, 1, 2, 6.
Of those 6, how many were substantive blog entries as opposed to comments?
That would have been 4.
Of those 4, how many had educational notes posted to them?
All of them.
Did other students view these notes?
Yeah, I actually had students coming up to me outside of class thanking me for posting on my blog.
Alex, in her opening statement, Ms. Gupta claimed that you used profane and vulgar language. Did you use expletives in your blog?
Yes, I did. And while I realize that my mother may not necessarily approve of my using that language, it's a perfect example of how I use my blog to just blow off steam about Professor Lee. And, well, unfortunately, that's how kids talk nowadays.
Alex, let's put a timeline to everything that occurred. When was your first entry to your blog?
My very first entry would have been, gosh, right when I returned home from summer camp. I actually emailed a link to my blog to my friends Jamie Pressel and Morgan Lovemark since they went to summer camp with me, so we could share pictures and things like that.
When was your first blog entry, though, to Exhibit B?
My first blog entry to Exhibit B would have been Monday, November 2nd.
When was the entry that got you in trouble?
I'd really like to be able to answer your question, Mr. Strunk, but I just don't know. I mean, I made a series of posts over just 4 days, and right after that, I was called into the principal's office and told I was being suspended.
When was your final post to Exhibit B, though?
That would have been, Friday, November 5th.
And when were you suspended?
Just a few days after that.
Alex, were you only suspended, or was there more?
No, there was so much more. Not only was I suspended, but I can't participate in any extracurricular activities. I can't walk in front of my friends and family at graduation. I can't even go to my senior prom.
How long does that mean you won't be able to participate in school activities, Alex?
The rest of my senior year.
To your knowledge, why were you so severely punished?
That's just it. I don't know. I mean, I was told it was because of my blog and the disruptive influence it had on the school, but I was just trying to learn. I don't understand.
What effect has this severe punishment had on you?
Well, I've been working 12 years, 12 whole years, for the day that I get to don my cap and gown and walk in front of my friends and family to receive my diploma. And now I can't even do that. All because I was trying to learn.
Thank you, Your Honor. No further questions at this time.
Cross-examination.
Yes, Your Honor. Permission to step aside from the podium, Your Honor?
Granted.
Ms. Leslie, before I begin, I'd like to introduce myself. My name is Clement Dupuis, and I'll be asking you a few questions on behalf of Erehwon High School.
Good morning, Mr. Dupuis.
Now, Ms. Leslie, when you first created your blog this school year, you posted your class schedule on it, didn't you?
Yes, I did.
And your friend, Jamie Pressel, posted his class schedule on your blog as well, right?
Jamie's a she, actually, but yes.
Excuse me. And Morgan Lovemark posted his or her class schedule onto your blog as well, correct?
Yes, she did.
And those are both students at Erehwon High School, aren't they?
Mm-hmm.
And now, when you made those postings, you found that you all shared Professor Lee's AP European History class. Is that right?
Yes, that's correct.
And you'd agree with me, Miss Leslie, that AP courses are difficult courses, right?
Well, they're college-level classes, so yes.
And so because of Professor Lee's course and its difficulty, you decided to post notes on your blog, didn't you?
Well, yes. I found that it was rather difficult to learn some of the material in Professor Lee's class.
I'm not asking you if you found if the material was difficult. I'm merely asking you if you posted notes on your blog.
Yes, I did.
And in fact, you knew at that time that students were accessing those notes, didn't you?
At first I knew that Jamie and Morgan were, but then other kids caught on later on.
And in fact, as you stated on direct examination, isn't it true that students were approaching you in school thanking you for blogging about Professor Lee's class?
Yes.
And now you continue to post your notes on that blog through the first week of November, did you not?
Yes, that's correct.
And during that first week of November, you also posted about events that occurred in Professor Lee's AP European History class, didn't you?
Such as?
Well, I believe on page 90 you have a discussion between Professor Lee and Jeff Woodall. Do you recall that entry?
Yeah, I recall that one. Professor Lee cut Jeff off yet again.
So, yes, you do recall posting about events in Professor Lee's class then?
Yes, I do.
And in fact, on November 2nd, you posted about a discussion you'd been having on nuclear proliferation, as you mentioned on direct examination?
Yes.
And that discussion lasted 5 minutes in class, didn't it?
Yes, it did.
And during that week, is it not true that you were learning about the French Revolution?
Yes, that's correct.
And you didn't agree with the opinions that Professor Lee was expressing in the classroom, did you?
Regarding
Nuclear proliferation.
Of course not. She talked about just murdering millions of people.
So you didn't agree with her comments, right?
No, not at all.
So you took it upon yourself to challenge Professor Lee, didn't you?
Yes, I did. I mean, I don't think that's morally right at all.
Your Honor, motion to strike as to whether, or excuse me, motion to strike the portion of the witness's response regarding whether or not Professor Lee's comment was appropriate. The question asked whether or not she challenged it, not if it was appropriate.
Response.
Your Honor, this is the second time that Mr. Dupuy has cut off my witness. In order to not mislead the court, it's important that she be able to answer the question to the full of her ability.
Your Honor, may I respond?
Objection granted. The non-responsive portion will be stricken from the record.
May I proceed, Your Honor?
You may proceed.
And after you challenged Professor Lee asked the class to get back to the materials, didn't she?
Yes, I believe she did.
And after she said that, you challenged her again, didn't you?
Yes, Mr. Dupuy.
And now
That's
after
not
class,
a matter to be taken lightly. At least I don't believe so. I'm rather passionate about it.
Your Honor, I move to strike the portion of the witness's response regarding her passion. The question asked simply if she challenged the opinion, not whether or not she was passionate about her challenge.
Response.
Your Honor, the witness's response was completely responsive to the question which Mr. Dupuy posed.
Objection will be overruled.
And so after class that day, you decided to approach the student teacher, Chris Richmond, correct?
Mr. Richmond, yes.
Mr. Richmond? And would it be fair to state, yes or no, that Chris Richmond wasn't able to help you?
Yes, that's correct.
And in prior sworn testimony, you've stated that at that time, you knew that you, quote, had to take action on your own. Isn't that correct?
That's how I felt at the time, yes.
And so that night, you posted about Professor Lee's class and that discussion, didn't you?
Yes, I did.
You titled your entry, quote, Professor Lee's an unimaginative jerk, didn't you?
Yes, I did. That's a good example of venting.
Yes or no, did you call Professor Lee an SOB in the opening paragraphs of your blog?
Yes, I did.
And in fact, on November 5th, isn't it true that you went so far as to state expletive that and expletive Lee on your blog?
Yes, more venting.
And you'd agree with me, Miss Leslie, that those expletives are profanities?
Yeah, yes, I would. I mean, once again, I was simply venting.
And Miss Leslie, to be clear, you wouldn't say expletive this and expletive you to a teacher in class unprovoked, would you?
Mr. Dupuy, I was posting this from my home. I never dreamed anyone would see it.
I'm asking you simply, yes or no, would you make that comment to a teacher in school unprovoked?
No, I would not. I was posting this from my home.
And in fact, isn't it true that that type of conduct would be punishable under the Erehwon disciplinary code?
I'm not sure. I'm sorry.
So you're not familiar with the code, you're not familiar enough with the code to know that it prohibits profanity? Is that what you're testifying to this court?
I'm familiar with the code. Would you be able to point out where it says that?
I'll just move. Well, is Exhibit A still at the witness stand, Ms.
Yes,
Leslie?
it is.
Your Honor's permission to approach the witness?
Granted.
Excuse me. Now, I'd like to direct the court's attention to what is page 86 on this copy of the exhibit, number 15. Please follow along silently as I read aloud. Obscene, vulgar, and or profane language, obscene gestures, written or pictorial. That falls under the major infraction section of the code, does it not?
I believe it does, but once again, this is Erehwon's high school disciplinary code, and I was posting this from my home.
And now, Miss Leslie, as you mentioned earlier, you were venting on your blog, right?
Yes, I was. That was one of the 3 purposes.
And you told you told your fellow classmates that they could use your blog as a form to vent about Professor Lee, didn't you?
Well, yes, I think that's more constructive than, as you said, just walking up and saying something like that to his face, her face.
I move to strike the portion of the witness's response as to that comment being constructive. The question merely asked whether or not it existed, not whether or not it was constructive.
Response.
Your Honor, the question was open-ended and called for that response. Whether or not Mr. Dupuy liked the answer, it was responsive to his question.
Your Honor, may I respond?
Objection overruled.
And furthermore, Students commented back on your blog, didn't they?
Yes, they did.
In fact, you were, quote, amazed by the amount of comments you were getting. Isn't that correct?
I was. I was amazed that so many kids felt the same way.
And from your observations, it seemed like everyone at school was talking about your blog. Isn't that correct?
Well, everyone in terms of hyperbole, of course.
And in fact, from your observations and prior sworn testimony, you stated that it seemed like everyone had been on your website at one point or another. Isn't that correct?
Yeah.
And on your blog, Miss Leslie, isn't it true that you asked students to ask more questions in class?
Well, yes. I mean, I think we should take our education into our own hands, of course.
Miss Leslie, yes or no, did you ask them to have more discussions?
Yes.
And in fact, from your observations, they were asking more questions in class, weren't they?
Yes, and everything was going very well.
And on your blog, you stated that if Professor Lee didn't like your questions, that you could just ignore Professor Lee, didn't you?
That's just another example of blowing off steam.
So, yes?
Yes, I did state that.
And in fact, yes or no, didn't you state that that you could pretend like Professor Lee wasn't even in the room?
Yes, we never actually did that, of course.
Yes or no, isn't it in fact true that you stated on your blog that you and your classmates could make up your own lectures in Professor Lee's AP European History class?
Yes, but once again, we never did that.
And isn't it true, Miss Leslie, that on November 5th, in your blog entry, you stated that it was, quote, time to take over the class?
Could you point out where that is in here?
Your Honor, permission to approach the witness?
My apologies. I don't have the whole thing memorized. Let's see.
I'd like to direct the court's attention to page 91 of Exhibit B. It is the last paragraph before the comments section. Please follow along silently as I read aloud, Miss Leslie. Quote, "It's time for us to take control of the class," end quote. Did I read that correctly?
Yes, you did, and that's absolutely correct.
And Miss Leslie, isn't it true?
Objection, Your Honor. This is the 6th time that Mr. Dupuis has cut off my witness. So as to not mislead the court, it's important that she be able to explain the intention behind her blog as it goes directly to the facts at issue in today's case.
Your Honor, may I respond? Your Honor, I'm merely trying to ensure that Miss Leslie gives responsive and relevant answers. Any issues may be brought up and redirect if necessary.
Objection overruled.
And isn't it true, Miss Leslie, that on your blog you stated, quote, "Maybe if enough people read about how awful, awful, awful Lee is, something will change"?
Yes, that's what I hoped.
Thank you, Your Honors. No further questions.
Does counsel have redirect?
Yes, Your Honor.
You may proceed.
Alex, Mr. Dupuis referenced several postings that you made to your blog during his cross-examination. Did you use a computer to post these messages?
Yes, I did. And if I could actually clarify one of those, Mr. Strunk.
Sure, Alex.
Let's see. Right here, the one that he most recently referenced, "It's time to take control of our class." I believe that we should really take our education into our own hands. I mean, we're being constantly cut off in class by Professor Lee, and it's very important that we learn, and that's a great way to do it. I mean, we should really take control of our own education.
Alex, did you use a computer to post that message?
Yes, I did.
Who gave you that computer?
My parents.
Outside the scope of cross-examination.
May I be heard, Your Honor?
Response.
Your Honor, during his cross-examination, Mr. Dupuis referenced all of these messages which Alex posted to her blog. We're simply establishing where she was at the time that she posted these messages, which goes directly to the heart of this case as she was doing this from within her own home. He opened the door for this line of questioning during cross-examination.
Your Honor, may I respond?
I think the question went beyond redirect, so the objection will be sustained as to where she got the computer.
Alex, who helped you set up this blog?
Objection. Outside the scope of cross-examination.
Response.
Your Honor, this goes directly to mitigate the point that Mr. Dupuis brought up during cross-examination regarding the intention of my witness. If I may proffer, she will go on to testify that her mother helped her set up this blog and was an instrumental part in constructing it, making it less than the monstrous system of postings that Mr. Dupuis would have the court believe it is.
Your Honor, may I respond?
Yes.
Your Honor, I never inquired as to who helped her set up her blog or in any form of the question that Mr. Strunk is attempting to ask.
The objection will be sustained.
Alex, where were you when you posted these messages which Mr. Dupuis referenced?
Every single posting that I made was from within my own home.
Did you ever do anything on your blog during school hours?
No, never.
Thank you. No further questions.
Any recross?
Yes, Your Honor.
May proceed.
Miss Leslie, did you or did you not state that it was time to take control of the class on your blog?
Objection, Your Honor, asked and answered.
Your Honor, may I respond? Your Honor, this is recross examination. I'm merely laying a foundation. However, I could move on if the court would like me to.
Yes, I believe recross is limited to the redirect.
Yes, Your Honor.
Objection sustained.
And that statement that you made was in regard to Professor Lee's AP European History class, correct?
I'm not sure which statement you're
Statement
referencing.
regarding taking control of the class.
Yes, I believe you're taking it out of context, however, but yes.
And you directed that statement at students in Professor Lee's AP European History class, correct?
I merely wrote out something on my blog. If someone chose to listen, then that's them.
No further questions, Your Honor.
May I step down, Your Honor?
Yes, the witness be excused.
Thank you.
Plaintiff may call the second witness.
Good morning, Your Honor.
May I proceed?
Please.
Could you please state your name and current occupation for the court?
Yes, my name is Dana Clark. I'm currently the chair of the history department at the high school.
And how long have you been chair of the history department?
For the past 15 years.
What would you say, as chair of the history department at the school, your job typically entails?
Well, as chair, I naturally lead all of the department meetings. I also serve as a liaison between the school board and the department to ensure that the curriculum is meeting district, state, and national academic standards. I also work with Principal Thompson as a consultant. We help mediate issues between students in the history department.
How else, if at all, are you involved at the high school?
I'm also a teacher. I teach freshman world history, American history to juniors, and an AP seminar on the Civil War.
And Ms. Clark, for how long have you been teaching?
It's my 22nd year.
Your Honor, at this time, based upon her extended experience and knowledge, we ask that this court recognize Ms. Clark as an expert in the high school educational environment, as well as high school conflict mediation, pursuant to Evidence Rule 702.
Your Honor, the defense has no objections to Professor Clark being an expert within the field of high school education. However, we do reserve the right to object on any opinions that Professor Clark may testify to.
Okay. Granted.
Ms. Clark, do you know Alex Leslie?
Yes, I know Alex.
How do you know Alex?
Alex was actually a freshman in my world history course 3 years ago.
How would you characterize your experiences with Alex in the classroom?
As a student, I would say that Alex was a great student, almost remarkable. She received an A both semesters. She was generally well prepared for class. She was also an active participant in discussions. As a freshman, that's a remarkable thing to see.
Are you familiar with Professor Lee?
Yes, I also know Professor Lee.
How do you know Professor Lee?
Professor Lee is one of 5 teachers within my department that I'm required to know. And also, when she joined our faculty about 18 years ago, I was her informal mentor.
Now, you said you helped to mediate conflicts between students and teachers. Are you at all familiar with the conflict between Alex and Professor Lee?
I am.
And how did you become aware of this conflict?
I became aware of this within my own classroom shortly before Alex was suspended.
Now, to the best of your knowledge, Ms. Clark, how was the conflict between Alex and Professor Lee resolved?
Well, as you heard Alex say herself, she was suspended for 10 days and banned from school activities. Also, Principal Thompson shut down the school's wireless network to sever access to the blog.
Ms. Clark, you said once again that you're involved in mediating conflicts between students and teachers. In this case, were you at all involved in the mediation of the conflict between Alex and her professor, the punishment?
Strangely, no. I was left out of the loop on this issue.
Ms. Clark, I'd like to refer to what has been previously stipulated as Exhibit A. Do you have a copy up there with you?
I do.
Okay, you talked a little bit about Principal Thompson's reaction and his punishment for Alex. do you have an opinion within a reasonable degree of certainty in your field as to whether there were other measures that could have been taken to deal with Alex's situation?
I do.
And on what do you base this opinion?
Well, I base this off of 22 years teaching with high school students, also 15 years as an expert mediating conflicts, also my understanding of Alex as a student, Professor Lee as a teacher, and the blog she created in our school's disciplinary code.
And what is your expert opinion?
Well, it's my opinion, if I can refer you to the back of the disciplinary code, Your Honors, that there are several lesser actions that would have and should have been taken.
Relevancy? If Your Honor, I may explain.
Yes, please explain your objection.
Your Honor, the issue in today's court is the disruption that Alex Leslie's blog caused within the school, not any other options that Principal Thompson could have been taken, as those other options do go towards a point of due process, which is not a factor within today's case, therefore making it irrelevant under Rule number 401 and irrelevant as to the due process according to number 9 on the errata sheet.
May I respond, Your Honor?
Yes.
This testimony is certainly not irrelevant, and it does not go to the issue of due process. The plaintiff is offering this testimony pursuant to the U.S. Supreme Court case Reno v. ACLU, and that case held that an overly broad resolution or an overly broad punishment, such as this one in this case, led to a chilling effect on student speech or on speech in general. We're not offering this testimony to go towards due process. We're offering it to go towards the chilling effect that Alex's punishment had on her and on the school.
The objection will be overruled. You may proceed.
Would you like me to re-ask the question?
No, I'll just continue. There are several lesser actions that have been taken over the past 12 years that help mediate conflicts like this, such as number 3, a teacher-student conference, and this would have mediated this particular conflict.
Now, were you here during Alex's cross-examination?
Yes, I was.
Did you hear Mr. Dupuis reference the comment on her blog that we should just take control of the class and ignore Professor Lee?
Yes, I did.
Are you familiar with Alex's blog?
Yes, I've read it thoroughly, of course.
Okay. Now, Ms. Clark, being a teacher for 22 years now, do you have an opinion within a reasonable degree of certainty as a teacher as to the comments like that one or those ones that were made on Alex's website?
I do.
And on what do you base this opinion?
Well, on my same expertise, but most importantly, my understanding of this blog.
And Ms. Clark, what is your expert opinion?
Well, it's my opinion that students are bound to complain, especially high school students, whether it's about, a teacher and how hard the classroom is, or that the class is too cold, even that the sloppy joes in the cafeteria just aren't sloppy enough. A student is going to complain. It comes with the territory, and teachers must develop a thick skin.
All right, Ms. Clark. Now, in her opening statement, Ms. Gupta claimed, and I quoted this, Alex's blog caused a substantial disruption within the entire school. How did the blog impact your classroom?
Well, surprisingly, the blog itself did not have any significant disruption in my class. In fact, if I hadn't talked to Principal Thompson about her reaction to the blog, I'm not sure that I would have known there was a problem at all. In fact, it was her decision that caused any sort of disruption in my class.
What was Principal Thompson's decision?
Well, Principal Thompson decided to shut down the school's wireless network.
And how did Principal Thompson's decision impact your class?
This decision upset some of my students. They had to access hard copies of materials. I had to use some of my time to make these hard copies. We didn't have access to our email accounts. Several inconveniences.
Now, Ms. Clark, do you have an opinion within a reasonable degree of certainty in your field as to the response Principal Thompson had to the situation?
I do.
And on what do you base this opinion?
I base this more off of my 15 years being a conflict mediator.
And what is your expert opinion?
It's my opinion that, unfortunately, in this situation...
Improper opinion?
Your Honor, this is not an improper opinion. She's giving her opinion pursuant to Evidence Rule 702, and you heard her state that she's been mediating conflicts for 22 years now. She's qualified as an expert in the high school educational environment and conflict mediation. This isn't an improper opinion.
Your Honor, may I respond?
Yes.
Your Honor, while under Rule 702, Professor Clark is an expert within the field and can base an opinion off of her knowledge of that field, she was not present within Professor Lee's classroom to observe the disruptions going on within that classroom or aware of all of the data that Principal Thompson had to base his suspension of Alex off of. Therefore, she does not have the personal information and knowledge that would instigate a proper opinion of the matter.
May I respond, Your Honor?
Objection is going to be overruled. You may proceed.
Would you like me to repeat the question, or
Yes, please.
Do you have an opinion within a reasonable degree of certainty in your field as to Principal Thompson's punishment and the response he had?
I do.
And on what do you base this opinion?
Again, off of my expertise and my understanding of this particular conflict.
And what is your expert opinion?
It's my opinion that in this situation, Principal Thompson overreacted, and it was a disproportional response to the situation. I'd even go as far to say that it was a $50 punishment for a 5-cent crime.
And as a teacher for 22 years, why would a teacher dole out a $50 punishment for a 5-cent crime?
Well, the only reason why such a severe punishment will be offered is to have a deterrent effect and to keep students from preventing.
Personal knowledge. The witness cannot testify as to why Principal Thompson gave out the punishment that he did.
May I respond, Your Honor?
Yes.
My question didn't ask her why Principal Thompson gave her the punishment that she did. I asked her why a teacher would dole out a $50 punishment for a 5-cent crime. And being a teacher for 22 years, certainly that's a question she'd be able to answer.
Objection overruled.
Please continue, Ms. Clark.
Yes. The only reason why a teacher would have such a severe punishment in this situation is to have a deterrent effect and to keep any student from committing the same actions in the future.
Thank you. No further questions at this time.
Defense may cross-examine.
Yes, Your Honor. Ms. Clark, before I begin, my name is Smriti Gupta, and I will be asking you a few questions today on behalf of the defense, the Erehwon School District.
Good morning. Do you pronounce it Gupta or Gupta?
Gupta.
Gupta. Okay. Yes. Good morning.
Now, Ms. Clark, I do believe on direct examination you stated that you've been a teacher for 22 years now. Is that correct?
Yes, it's unbelievable.
And you've been the chair of the history department for the last 15. Isn't that right?
That's correct.
And would you agree with me, as an expert within your own field, that is the responsibility of the school to provide an educational environment for the students?
Yes, of course. That's why there's a building, and that's why they're teachers.
And the teachers themselves also have that responsibility to maintain that environment within the classroom. Would you agree?
Yes, that is correct.
And the students have their own responsibility to pay attention and learn within the class. Am I correct?
Yes, if they want to receive a good education, of course.
And it's important for the teacher to be able to control the classroom environment and stop any disruptions that may happen. Would you agree?
Well, it depends on the disruption that you're referring to.
Well, isn't it true that, in fact, in prior sworn testimony, you stated that if teachers don't keep control of the classroom, the students could eat them alive?
I don't quite remember making that statement, but yes, that is true. Teachers must maintain control. However, disruptions are very vague, and it depends on the teacher and their teaching style.
But you would agree the students can cause disruption within the class, and that's not ideal for the classroom environment, is it?
Yes, that is true. Disruption is a general term.
All right, well, let's move on. Now, you have known Professor Lee for quite a while now, haven't you?
18 years.
And in fact, when she first arrived at Erehwon High School, you served as her mentor, didn't you?
I did. We've worked together ever since.
And you were in the peer-to-peer program with her.
We still are in that district-wide program.
And in that program, you were able to view her teaching style, weren't you?
Yes, and not worry. This is a thing that's going to be going on as long as we work together.
So that's a yes, you did.
Yes, and currently we're still working together to offer tips and tricks to enhance each other's effectiveness.
And, Professor, am I correct in stating that Professor Lee teaches multiple AP classes?
Yes, I believe that she teaches AP French as well.
And you teach an AP class as well yourself, an AP seminar on the Civil War, I believe.
I do.
And would you agree with me, Ms. Clark, that AP classes require a great deal of work from the students?
Yes, that is true. They're very rigorous.
They're very difficult and demanding classes?
Yes, they often mirror introductory college-level courses.
And even intelligent students within those classes often have problems, don't they?
Yes, and many of the students find ways to supplement their education.
And in fact, Alex, you're aware of Alex's blog, aren't you?
Yes, I am.
And you've read the various comments that Alex made on that blog?
Yes, I've read all of the blog.
And you've read, If you look at page 87 on the front of the blog, would you agree that in the first paragraph, Alex makes a statement calling Professor Lee an SOB?
Yes, she wrote that.
And would you consider that an expletive?
Yes, it is an expletive.
And you're aware of the Erehwon School District's disciplinary policy as well, aren't you?
Yes, of course.
And this policy prohibits profane language, doesn't it?
Yes, it did, but I'm sure you heard Alex testify earlier that she was merely venting.
Your Honor, motion to strike the latter part of witness's testimony as far as Alex venting within the class. The question asked whether or not the policy did not allow for vulgarities.
Your Honor, if I may respond, Ms. Clark was just fully responding to Ms. Gupta's question, and so as to not mislead the court, Ms. Clark and all the witnesses should be permitted to fully answer the question.
Objection sustained. The witness will be responsive to the questions.
And Ms. Clark, if you turn to page 90 of the blog, I believe that is November 5th, Alex makes a comment about halfway down saying, well, expletive that and expletively. Is that correct?
Do you mean on page 90 because that's November 4th?
Oh, I'm sorry, page 91.
91. Can you point out the comment again? I'm sorry.
Yes. Your Honor, permission to approach the witness.
Granted.
Right here. Would you agree that it says, well, expletive that and expletively, I say?
Yes, that's posted.
And you would agree those would be considered profanities, wouldn't they?
Yes, in some general sense. I'm not sure exactly what word was used, but yes, that's correct.
And again, profanities are not allowed under the Erehwon School District's disciplinary policy.
Generally speaking, that's correct.
And would you agree that, and let's talk about the blog's effect in your classroom. You heard about it from students within your class, didn't you?
Yes, they were upset about Principal Thompson's reaction to the blog.
And in fact, the network had been shut down shortly after you read the blog, isn't that right?
Yes, that is not correct, unfortunately. I hadn't read the blog until after the network had been shut down.
All right, sorry, my mistake. The students in your class were frustrated by the fact that the network was shut down, weren't they?
Yes, some of them were upset. They had to access hard copies. They're used to using the laptops in the classroom.
And in fact, you had to stay after school one day to print out hard copies for the students, didn't you?
I did. We always have hard copies, but one day I had to make a few extra photocopies.
And you couldn't access your email during class, could you? Yes or no?
For that period, no, I could not.
And the students couldn't access their emails either, could they?
They couldn't access their email accounts on the internet, that's correct.
And this caused problems for your class, didn't it?
I wouldn't say that it caused problems. I was frustrated, and I did go talk to Principal Thompson.
In fact, as one of your job requirements is a mediator between the students and the teachers, isn't that correct?
Yes, of course.
However, you weren't involved in this investigation between Principal Thompson and Alex Leslie's blog, were you?
Surprisingly, no, I was left completely out of the loop.
After learning about the blog, you didn't approach Professor Lee to ask her about the blog or its effects on the classroom, did you?
No, I did not.
You didn't talk to Alex Leslie about her blog and why she posted what she did you?
I did talk to Alex, yes.
You did talk to Alex?
Yes.
Ms. Clark, am I to understand that your testimony today is that after you learned of the blog, you talked to Alex Leslie about her blog?
Yes, that is correct.
Your Honor, permission to approach the witness with a copy of her affidavit?
Granted.
Let the record reflect I'm showing opposing counsel an unmarked copy of the witness's affidavit. Permission to approach the witness, Your Honor?
Granted.
If you could follow along here, around page 70, lines 242 to 246. I encourage students to think critically about the ideas and issues we discuss in class and like to use the students' comments as a teaching tool, sort of like the Socratic method that you might see in law school.
Objection, Your Honor, improper impeachment. My witness has made no contradiction to her statement. As you can see, there's no in her statement that says that she doesn't talk to Alex Leslie, and therefore Ms. Gupta's impeachment is improper.
Your Honor, may I respond?
Objections overruled. Proceed.
The next line, I became aware of the blog Alex created and the post about Professor Lee shortly after Alex was suspended.
You read that incorrectly. It says shortly before Alex was suspended.
Shortly before Alex was suspended.
Yes, that's correct.
Now, Ms. Clark, does it say anywhere within that paragraph that you talked to Alex after learning about the blog?
No, it does not. However, of course I've talked to Alex before appearing in court and since being here today.
Your Honor, motion to strike the witness's response, the latter portion of witness's response as to talking to Alex before court and after writing the deposition, as it was not responsive to the question.
Your Honor, it's perfectly responsive to the question. Ms. Gupta is trying to impeach my witness based on something that's not contained within her statement. According to mock trial rules, on cross-examination, witnesses are allowed to extrapolate from their statements if the question so calls for it, and if it does not materially affect the case, and if there is no contradiction to it in their statement. There is no contradiction to the fact that she did talk to Alex. Ms. Gupta directly asked for the question that wasn't contained within her statement, and my witness is free to answer as she pleases whether or not Ms. Gupta likes the answer.
The objection will be sustained and the response of the witness stricken from the record. You may proceed.
Ms. Clark, am I to be clear that you didn't talk to Kendall Dell, the school's IT director, about the blog either?
That's correct. As you stated earlier, I was left out of the loop on this situation.
No further questions, Your Honor.
Plaintiff's counsel may redirect.
Briefly, Your Honor. Ms. Clark, on cross-examination, Ms. Gupta brought up Principal Thompson's reaction in Alex's situation. Who caused the disruption in your classroom? Alex or Principal Thompson?
However,
Objection,
insignificant.
leading question.
Your Honor, my witness is free to answer however she likes. It's not a yes or no question.
Objection will be overruled. You may proceed.
Yes. However insignificant any disruption was, all of it can be attributed strictly to Principal Thompson and not Alex and the blog she created.
Thank you. No further questions at this time.
Any recross?
Yes, Your Honor, just briefly.
You may proceed.
Now, Ms. Clark, opposing counsel just asked you about the disruption within the classroom that you had. Do you recall that line of questioning?
Yes, I do.
In fact, would you agree with me that the network shutdown affected your class, correct?
Yes, of course.
And that network within the school was shut down because of Alex Leslie's blog?
Well, I can't say why Principal Thompson decided that that was the proper means of taking it. But yes, the network was shut down, and it was rather inconvenient.
No further questions, Your Honor.
Okay, the witness will be excused.
Yes, Your Honor.
Your Honor, at this time, having already submitted our exhibits into evidence, the plaintiff rests its case in chief.
All right. The defense may proceed to call your first witness.
Your Honors, the defense calls Professor Lee to the stand. May I proceed?
Please.
Please state your name for the court.
My name is Professor Grace Lee, and I'm a teacher at Erehwon High School.
And what classes do you teach there, Ms. Lee?
I teach Honors History, AP French, and AP European History.
How long have you taught those classes?
AP French and Honors History go back a number of years, since I started teaching about 18 years ago, though AP European History is a little more recent and was started 3 years ago.
So what's the difference between your honors course that you teach and your AP courses?
Both courses are very demanding, and they challenge the students intellectually. However, honors courses have much more flexibility, as they have a lot less material that's needed to be covered over a longer period of time. In AP courses, on the other hand, there is vast amounts of material that's needed to be covered in order for the students to pass a standardized exam at the end of the year. And because of the time restraints, we have to have the class very structured in order to get through that needed material.
So what happens if you don't end up going through all the material that's needed?
Well, at the end of the year, the students have the option to take the standardized test in order to get credit for college. And were the students to fare well on that test, they can get credit for college, and they are also eligible for more scholarships. And colleges tend to look favorably upon students who have AP courses on their transcripts.
And Ms. Lee, so aside from that, were you aware of who Alex Leslie was prior to this semester?
I didn't have Alex in any of my classes, so no, I wasn't.
Are you aware of who she is currently?
Yes, she's currently taking my AP European History class.
And based on your observations of Alex within the classroom, how would you describe her?
Alex is a bright student. She has a lot of potential. However, that potential is wasted on when she was disruptive in class, when she would disrespect me, and when she was overall rebellious.
There's been a lack of foundation to show how Alex Leslie specifically disrupted the class. Moreover, this testimony that Ms. Lee is giving pursuant to my witness is improper character testimony pursuant to Evidence Rule 404.
Your Honor, may I respond?
Please.
Your Honor, in addressing opposing counsel's objection to improper character testimony, Professor Lee is not giving any any testimony towards Alex's propensity to act in such a way outside of the classroom and in other events as character testimony entails. However, she is merely testifying to her observations of Alex within the classroom.
Objection is overruled. You may proceed with your examination.
Now, Ms. Lee, why do you describe Alex that way?
Well, since the very beginning, Alex would interrupt me while I would try to teach the class. And, well, for example, on the very first day of class, no sooner than I had just passed out this class syllabus, that she made snide remarks about the reading assignments.
Did she ever do that again?
Yes, in fact, a couple days later, when the first reading assignment was due, I could tell that the majority of the classroom hadn't completed the assignment. And so in order to instill in them the importance of preparation, I had the class read the introductory chapters. And in the midst of it all, Alex commented on it being a waste of time several times.
Did Alex ever give you any other problems in class, Ms. Lee?
It basically just went like that, with Alex interrupting me while I would try to teach. But then it all escalated in that first week of November with her blog entries.
What happened in that first week?
Well, it was in that first week that I noticed an uprising in the students acting up. They were getting out of hand, and it was also towards the end of that first week that I learned about Alex's blog. And it got to a point in class where all the disruption was getting so out of hand that I had to take the blog and what was happening in class to Principal Thompson.
Objection, Your Honor, lack of foundation. There's been a lack of foundation pursuant to Evidence Rule 602 for this witness to testify how specifically this blog contributed to this alleged disruption she's describing in her classroom. She's given no testimony that shows how specifically she knew it was Alex's blog that caused the disruption.
Your Honor, may I respond?
Yes.
Professor Lee is basing this testimony on her own observations. If the court requires, I will return to my line of questioning in which Professor Lee will describe how she came to this conclusion.
Objections overruled.
Now, Ms. Lee, when did you first become aware of this blog?
It was towards the end of that first week of November.
And how did you hear of it?
Alex and other students were constantly talking about the blog, and so eventually I just pieced two and two together and I read the blog myself.
Is there a copy of the blog at the stand?
Yes, there is.
Could you please categorize for the court what you read within this blog?
Well, when I read the blog, these blog entries of November, I found that Alex made personal attacks towards myself. She also criticized my teaching style, and she encouraged classroom chaos.
Ms. Lee?
Your Honor, once more, this is a lack of foundation. There's been a lack of foundation to show how specifically Alex incited classroom disruption, or, as she said, classroom rebellion. She's given no comments, and pursuant to Evidence Rule 602, this is impermissible.
Your Honor, may I respond?
Yes.
Your Honor, Ms. Lee was, within the next question, Ms. Lee can describe how she came to that conclusion. Again, if the court requires, I will lay the foundational question.
Objections overruled. Proceed with your examination.
Now, Ms. Lee, you mentioned that Alex attacked you personally with this blog. Could you describe for the court how she did that?
Well, day after day in her blog entries of that first week of November, I was a target. She would title her blog entries such as, "Professor Lee is an unimaginative jerk," And then she would continue on to lace her blog entries with profanities and vulgar language. And she would even encourage other students to access her blog and to vent about me in it.
Could you give some examples of what you're talking about?
Yes, she called me a jerk. She called me an SOB. She also went so far as on November 5th to say, well, expletive that, and expletively, I say, and of course I wouldn't feel comfortable even repeating those words here in court today.
Oh, Ms. Lee, you also mentioned that Alex criticized your teaching style. How did she do that on the blog?
In her blog entries, she painted me as the sort of teacher who wouldn't allow for open class discussions or questions in class, and that just, it wasn't true. I have to remain a balance between...
Invention of fact. Nowhere in her statement does it say that it's simply not true that she doesn't allow classroom discussions.
Your Honor, may I respond?
Yes.
Your Honor, within Professor Lee's affidavit, she does talk about how she integrates classroom discussions into her classroom. And while Ms. Lee is not repeating verbatim what is said within her affidavit, she is providing a summary of what she said. If the court would require, I can point out the specific line within the affidavit.
Your Honor, if I may respond. According to Professor Lee's statement, she encourages students to voice their opinions and have discussions pursuant to the papers, the semester papers that she assigns. It doesn't discuss in her statement having class discussions or class seminars or anything of that nature, making this an invention of fact.
All right, the objection be sustained. You may clarify with the witness.
Move to strike the testimony, Your Honor.
I think you can clarify the witness's statement, so please proceed.
Ms. Lee, now, what did you mean when you said you provide time for discussions within the class?
So long as they are relevant, I do try to incorporate classroom discussions. However, I do have to remain a balance between how much time we spend on that and how much time we spend going over the needed materials so that the students can
Your
pass
Honor,
that.
I apologize for interrupting the witness, but that again is an invention of fact. According to line 324 of her statement, it flat out says that this does not provide time for in-class discussions outside of planned coursework, and she's testifying the contrary.
Your Honor, may I respond?
The objection is going to be overruled, and you can take it up in cross-examination.
Yes, Your Honor.
Please proceed with your examination of the witness.
Ms. Lee, the last point that you made was that Alex incited chaos on the blog. Could you describe how she did that?
Yes, in a comment that she makes in her first blog entry of that week, she encouraged the students to ignore me. She encouraged them to act as if I'm not in the room and to ask all sorts of questions and to make up their own lectures. And then again on November 5th, she encouraged the students to take over the classroom. And that was undoubtedly what happened in class.
What do you mean by that's what happened?
Well, that week in class, the students were ignoring me, and they were cutting me off as I was trying to teach. And they were asking all sorts of irrelevant questions, and it was getting difficult for me to teach. And it all paralleled. The students were acting exactly the way that Alex had been encouraging them to do so in her blog entries, and it was all getting out of hand.
What, if anything, did you do to try and control the situation?
Well, I tried to separate Alex from the group. I told the students to get back to work, and I told the students to quiet down, but nothing was working. These students weren't responding. It was getting out of control.
What, if anything, did you do after that?
It just got to a point where it was so chaotic within the classroom that I had no other option than to take the blog entries and everything that had been happening in class that week to Principal Thompson.
And to your knowledge...
Your Honor, invention of fact, nowhere in her statement does it say that she specifically went to Principal Thompson with the blog entries.
Your Honors, may I respond?
Yes.
Your Honor, within one of the last paragraphs of Professor Lee's affidavit, she does talk about the problems within her classroom and Principal Thompson's reaction and how he dealt with that problem. While it is not clearly stated within a line, I can read the paragraph for the court and show how, within the context, Professor Lee is staying within reasonable extrapolation of her affidavit.
Your Honor, if I may respond. According to mock trial rules, there is no extrapolation from the statement permissible on direct examination so as not to give any side an unfair advantage. It never says she went to talk to Principal Thompson, and I have the statement right in front of me. It says, when she talks about Principal Thompson, as Ms. Gupta cited, it simply says that Principal Thompson was right in his decision. It never says that she went to him. It never says she went to him with a blog or anything of that nature.
Your Honor, may I respond?
The objection will be sustained, and that portion of the witness's answer will be stricken from the record. You may proceed.
Ms. Lee, now before the first week of November, what was your class environment like?
It was much more manageable. I was able to teach appropriately.
And how was it like after Alex was suspended?
After Alex was suspended, the class tone and environment definitely improved. The students were compliant, and they were doing their work and paying attention in class, and we were productive with our class time.
Are you aware of the punishment that Alex was given?
Yes, I believe she was suspended.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
Please.
Professor Lee, you would agree with me that, like all the teachers, it's your responsibility to control your own classroom, isn't that right?
Yes, and I do what I can when I can.
Okay, and when you first heard about Alex's website, you were disappointed, were you not?
I was disappointed that Alex would encourage the students to do something like that, and her vulgar use of language.
Ms. Lee, so that's a yes. You were disappointed with the situation, isn't that right?
Yes, I very much was.
Okay, and you claimed in your statement that there was no other purpose for this website other than to create discontent and discord, in your opinion. Do I have that correctly?
Yes,
That's
absolutely.
what you thought? Okay, and you also said in your statement that, and I quote, that Alex did this for no good reason. Is that still your testimony?
Encouraging the students to act up in class? Yes, she had no good reason to do that.
Okay. Now, do you have a copy of the blog up there with you?
Yes, I do, ma'am.
Are you familiar with the website?
Yes, I am.
Okay, then certainly you're aware that on page 87 of the website, in the second to last paragraph, it says, click here for a PDF of my notes and let me know if you think I'm missing anything. Is that what it says?
Yes, you are correct.
Now, so it is your testimony today that when Alex posted that link with her notes, she's doing that for no good reason. Do I have that correct?
She was encouraging the students to act up, and that was for no good reason.
I'm simply asking you in regards to that one comment, and it is your testimony, isn't it, that she was doing that for no good reason? Is that right?
Her vulgar use of language, she had no use for that.
Objection. Excuse me, please continue.
She had no good reason to lace her blog entries with the profane language that she did. Yes, she did include her notes, but to get through her blog entries and read all of those...
I'm sorry, Ms. Lee, but I have to cut you off. My question didn't call for that. Objection, Your Honor, non-responsive. I simply asked her whether or not that one specific comment, in her opinion, was used for a good reason or if it wasn't. That called for a simple yes or no. I didn't ask her about any other vulgar comments in her opinion or anything like that.
The objection will be sustained. The witness will be responsive to the question.
Yes or no, Ms. Lee? Was that comment with her notes posted for a good reason in your opinion?
Well, I am not Alex herself, but yes, I suppose.
Okay. And on page 88, when Alex posted in the very last comment, first things first. Click here for my notes if you want my take on G. Lee's class today. Did I get that correct?
Yes, you did, ma'am.
Now, in regards to this one specific comment, it is also your testimony that she did this for no good reason. Is that right?
It was not her notes that I said she had no good reason for.
Okay, so then she had a good reason to post her notes. You'll concede that, right?
I suppose, yes.
Okay. Now, I'd like to establish a general timeline of everything that occurred. I think that helped the court. Professor Lee, generally speaking, students ask you questions in class, right? You're the teacher.
Yes, and I try my best to answer them when they are relevant to what we are going over in class.
Okay. And after Alex's blog was created, students began to ask you more questions. Isn't that right?
Irrelevant ones, all over the place, completely irrelevant to what we were going over in class.
But Professor Lee, nevertheless, those were more questions. Relevant or irrelevant, there were more questions, right?
Yes, that had no relevance to our topic at hand.
And the students also began to make more comments in the classroom. Irrelevant or relevant, they made more comments. Isn't that correct?
Yes, they didn't. It was getting difficult to teach because of their comments. There were so many of them.
Objection, Your Honor. Once again, that was non-responsive to my question. I asked her simply yes or no whether the students made more comments regardless of the fact whether they were relevant or irrelevant. I called for a simple yes or no, not her opinion on how they impacted her class.
Your Honor, may I respond?
Response.
Your Honor, the witness did answer at the end of her testimony that the students did in fact make more comments at the end of class and therefore is not non-responsive to the opposing counsel's question.
Objection's overruled.
So that's a yes. They made more comments. Relevant or irrelevant, they made more comments, right?
They made more irrelevant comments.
Okay.
Yes.
Now, then Alex was punished, right? She was suspended from school.
Yes, she was.
And did I get this right on direct examination? You said that the class atmosphere definitely improved after that. Do I have that right?
After she was suspended and who I believe the instigator of the discord was removed, yes.
So it definitely improved. That's right.
It did improve.
Okay. And after Alex was suspended and her blog was blocked from the school network, students began to ask fewer questions, relevant or irrelevant, right?
I would say that the participation in class was still pretty well, yes, but they weren't going off on tangents and we were on topic.
Professor Lee, yes or no, the students asked fewer questions?
Fewer irrelevant questions.
Okay, and they also made fewer comments. Relevant or irrelevant, they made fewer comments. Isn't that right?
They pretty much asked this, made the same amount of relevant questions, or comments, I mean, but the amount of irrelevant comments
Professor Lee,
decreased.
yes or no, they made fewer comments. That's all I'm asking. Regardless of whether they were relevant or irrelevant, they made fewer comments. Yes, isn't that correct?
Well, when you combine the irrelevant and relevant, yes.
Okay. Now, Alex was suspended for 10 days, right? You heard her say that?
Yes, I did.
And she can't walk at graduation anymore. Do I have that right?
Yes.
Okay. Well, I'd like to talk about Alex's punishment a little bit. You're a teacher, right?
Yes, that is correct. I've been teaching for 18 years.
Exactly. So then you know that part of deciding on a punishment for a student is the example it sets for other kids, right?
Yes, that is correct.
Okay. So you would agree with me then that generally speaking, and I'm sure there are exceptions, but the greater the punishment, the greater deterrent effect it will have on future students who are going to commit the same offense, right?
Objection. Question calls for speculation.
Your Honor, this question doesn't call for speculation. This is perfectly, the witness is perfectly capable of answering the question as she's been a teacher for 18 years, and she knows that she said that she knows that part of deciding on a punishment is the effect it has on other kids.
Your Honor, my objection still stands. The question is asking for Ms. Lee to speculate as to what would happen in the hypothetical situation. And it's not directly going to one of the issues at hand, which a hypothetical question must be in order to be used within court today.
Your Honor.
Objection sustained. You may proceed.
Yes, Your Honor. So, by your own admission, you would agree with me that Alex's punishment was severe. You said that in your statement, right?
It was pretty severe, yes, but the act that she encouraged the students to do was also very severe.
Okay, so you say that the actions to warrant her punishment were severe, and the punishment itself was severe. So then by deductive reasoning, the deterrent effect it had on other kids could also be severe as well, right?
Well, the students...
The question calls for speculation once again.
Your Honor, this question doesn't call for speculation. The witness is perfectly capable of answering this question based on her perceptions pursuant to Evidence Rule 602.
Your Honor, may I respond?
Yes.
This question still calls for speculation as it is opposing counsel has not given a direct context within the actual situation. There are multiple situations in which Professor Lee could testify to. The one that opposing counsel has offered is vague, and therefore Ms. Lee is forced to speculate in order to answer the question.
Objection sustained. You may rephrase the question if you wish.
Yes, Your Honor. Professor Lee, you would agree with me that if you caught a kid chewing gum in your class, and chewing gum was against the school rules, and you took it upon yourself to suspend the student, no student would probably ever chew gum in your class again, isn't that right?
I don't believe that a student would ever be suspended for chewing gum, nor is chewing gum even against the school rules.
But in that situation, no kid would probably ever chew gum in your class, isn't that right?
Objection. Once again, Your Honor, opposing counsel is asking my witness to speculate in her answer.
Objection sustained.
Yes, Your Honor. Now, you claim that Alex deserved her punishment, is that right?
Yes, because of the severity of the actions of the students and Alex included in that, in the classroom, and the disruption.
So you said that in your statement, and I want to make sure I have that correctly, that this is because such behaviors are not to be tolerated at our school. Isn't that what you said?
Yes, the discord in the classroom and the disruption and unenabling me to teach the classroom effectively.
Objection, Your Honor. This is non-responsive to my question. I asked her a simple yes or no question, and she keeps going beyond the scope of my question. I have a limited amount of cross-examination time, which I must split with my co-counsel, Danny, and I'd appreciate if the witness answered my question.
Objection overruled.
Now, you claim on direct examination that this blog, this website, was a personal attack on you. Did I write that down correctly?
Yes, with her vulgar language and her...
So that's a yes,
making me a
Professor.
target.
Objection, Your Honor. This is one of the multiple times that opposing counsel has cut off my witness while she was trying to answer the question. I request that opposing counsel give my witness time to answer the question to her fullest ability.
Your Honor, I simply asked her if I wrote down one of what she said correctly. That's a simple yes or no.
Objections overruled. Proceed.
So that's a yes. You claimed it was a personal attack. Do I write that correctly?
Yes, I was a target of her blog entries.
Yeah, exactly. So you also claimed you were a target. I have that correct too, right?
Yes, I was.
And you claimed that it criticized my teaching style, right?
Yes, she painted me as a sort of teacher that wouldn't allow for questions or open class discussions in class.
Okay.
But I have to remain that balance
Professor
between
Lee,
that.
I simply asked you once again if that is what you said on direct examination, and that is that she criticized your teaching style, right?
Yes, she did in her blog entries.
Now, you claim that this website was vicious towards you in your statement. Isn't that right? That was what you said?
Yes, that is correct.
And it was humiliating, right?
Both towards me and the school.
Okay, so it was embarrassing for the school, right?
Because of the discord that the blog encouraged.
So that's a yes. It was embarrassing for the school, right, in your opinion?
Yes, it was.
Okay. And you said on direct examination that you were worried that it caused people to think that your class was oppressive, right?
Yes, because of the way that she described me, but
So
it
that's
wasn't
a yes,
true.
Professor Lee. You were afraid it caused people to think that your class was oppressive, right?
With the way that she described me and how unfair it was, yes.
Okay. And it also, you were afraid that it caused people to think that you might be a substandard teacher. Isn't that right? That's what you said?
And my students generally excel on the standardized exams and in college, and I don't believe myself to be a substandard teacher.
Professor Lee, I'm sorry, I didn't ask whether you consider yourself to be a substandard teacher. I asked whether or not that was what you thought, and that is yes. Isn't that correct? You were afraid it caused people to think you were substandard.
With the way that she described me, yes.
Okay. Now, you claim that Alex violated your definition of common decency with these comments. Isn't that right? Yes or no?
With common decency, I'm sorry. What do you mean by that?
Well, in your statement, you flat out said that Alex violated your definition of common decency. Isn't that what you said?
Yes, she never approached me with these concerns. She went directly to her blog entries to vent about me.
But nevertheless, in your opinion, she violated your definition of common decency. That's a yes, right?
Yes, that is correct.
Okay. And now it's true that your definition of common decency may be different than mine. Isn't that right?
Well, yes, that is correct.
Okay. And then, so it's also true that your definition of common decency may be different than Judge Cupp's, right?
I suppose, but that's...
Speculation.
Your Honor, this question doesn't call for speculation.
Objection overruled.
So that's correct then. Yes, your definition of common decency may be different than that of Judge Cupp's, right?
But it's taken out of context with this situation.
Excuse me, ma'am, I'm sorry. I didn't ask you whether it was taken out of context. I simply asked you whether it could be different, and the answer to my question is yes, it could, right?
Yes, that is correct.
Thank you. No further questions at this time.
Does counsel wish to redirect?
Yes, Your Honor. Now, Ms. Lee, on cross-examination, opposing counsel asked you about the notes Alex posted on her blog. Do you recall that line of questioning?
Yes, I do.
Do you believe the notes on Alex's blog are worth any educational value?
Given everything that you had to go through to get to those notes, with the way that Alex used her language, the vulgar use of language, I believe it was very much like getting through a minefield to get to a playground.
Invention of fact, nowhere in her statement does it talk about Alex's blog being like getting through a minefield, and moreover, she can't testify to Alex's sentiments when she created the blog and what intentions Alex had. That's speculation under 602.
Your Honor, may I respond?
Yes.
First of all, rule number 602 is lack of personal knowledge, not speculation. And second, Ms. Lee's testimony is not speculation, as it is clearly her own opinion based on her own observations and personal knowledge of the blog.
Objection overruled. Proceed with redirect.
Were you finished with your question or your answer, or should I repeat the question?
No, I can continue, thank you. It was very much like a minefield, going through a minefield in order to get to a playground. Ultimately, it is not a playground if you have to get through a minefield. It is still a minefield. And getting through her blog entries with all of her attacks and her use of language, encouraging the students to act up in class, I don't believe that the notes were worth it, ultimately.
No further questions, Your Honor.
Thank you. Recross?
With the court's indulgence, may I have a moment, please?
Yes.
Briefly, Your Honor. You were here during Alex's testimony, isn't that right?
Yes, that is correct, I was.
And you said on redirect examination that these comments she made on her website were offensive, isn't that correct, and vulgar?
Objection outside the scope of redirect. I questioned the witness about the notes that Alex posted on her blog, not the comments Alex made.
Your Honor, however, the witness did go on to give quite an extensive answer about the rest of the blog and how vulgar and offensive it was.
Objection overruled.
So you claimed on redirect examination it was vulgar and offensive, isn't that right?
Her use of language was very vulgar, yes.
So you were here during Alex's testimony, then you certainly heard her say that she posted these comments in her house, right?
Well, yes, I did hear that.
Thank you. No further questions at this time.
The witness may be excused.
Thank you very much.
Defense may call your second witness.
Yes, Your Honor. The defense calls Kendall Dell to the stand. May I proceed, Your Honors?
Proceed.
Please introduce yourself to the court.
My name is Kendall Dell, and I am the Director of Information Technology for the Erehwon School District.
What is your educational background?
I have my bachelor's degree in computer science from the Cambridge Institute of Technology.
Now, you mentioned a moment ago that you were the IT director for Erehwon. Have you been employed prior to serving at Erehwon?
I was. Before I was hired at Erehwon, I was originally hired as a as a network systems analyst for a company by the name of Reptimach, which is an international accounting firm based out of Atlanta.
Did you hold any other positions at Reptimach?
I did. After I worked as a network systems analyst for a few years, I was promoted to that of a systems administrator. I held that position for another 10 years.
What were your responsibilities as a systems administrator?
Basically, I made sure that people in the company got the information that they needed, when they needed it, and where they needed it, by making sure that the computer systems at Reptimach were running correctly. To that end, I supervised a team of several employees, and I also dabbled in a bit of software development. I wrote a help desk program that answered several common questions at the company.
Now, what are your current responsibilities as an IT director?
I do basically the same thing that I did at Reptimach. I run the computer networks at the school district. I supervise a team of 4 employees, but I also help teachers develop new educational technology in order to improve their learning capacity in the classroom.
And when did you come to Erehwon?
It's probably been about 5 years now.
Why did you decide to come back?
Well, when I saw the job opening came up, Erehwon's my hometown, so I jumped at it.
Now, you mentioned that you help teachers incorporate technology in their classrooms. Do you have any other responsibilities as an IT director?
I do. I also perform network systems analysis.
Could you describe for the court what network systems analysis is?
Well, network systems analysis is basically looking at who's accessing what, when, where, and for how long in order to determine any type of loads that may occur on the computer network. So that I can...
Objection, Your Honor. As to invention of fact, nowhere in the witness's statement does it specifically define what network analysis contains, and the specific testimony that the witness is giving is not contained within his statement. and no extrapolation is permitted on direct examination.
Your Honor, may I respond?
Yes.
Your Honor, specifically within Mr. Dell's affidavit, he does state that he is a network systems analyst, and that he does perform functions relating to that. Furthermore, a closer look at his testimony will reveal that he discovered information in an investigation relating to the very results that he just talked about. Thus, this is not at all considered to be an extrapolation. If anything, it could be considered to be an interpolation of the facts already presented within the affidavit.
May I respond, Your Honor, briefly?
The objection will be overruled. You may proceed.
Were you finished with your answer, Mr. Dell?
No. What I do is I look at these different types of things in order to determine any types of loads on the computer networks to basically make sure that they don't get clogged and that the people get the information that they need.
Your Honor, at this time, given the fact that Mr. Dell will be testifying to technical information that requires a certain degree of technical expertise, we ask that he be recognized as an expert in the field of information and technology and data retrieval based on his education, training, and experience pursuant to Rule 702.
Your Honor, mock trial rules do not permit me to voir dire the witness at this time, and I will leave the determination of his expertise to your sound discretion. However, I would like to request permission to cross-examine him on his credentials later on.
All right, subject to that, the witness is determined to be an expert. You may proceed with your examination.
Yes, Your Honor. Now, Mr. Dell, are you familiar with the plaintiff in this case, Alex Leslie?
Yes, I am.
How did you find out about Alex?
Principal Thompson asked me to investigate Alex's blog.
And now, before we continue, could you briefly describe for the court what exactly a blog is?
Basically, a blog is a personal web page created by somebody through one of several free services that allows them to basically publish their comments, videos, pictures, different types of multimedia on basically whatever they want, and then have it viewed by the general public.
Now, specifically at Erehwon High School, how would a student access a website such as Ms. Leslie's blog?
Well, much like they'd access a website anywhere else, they would take the URL and go directly on their browser to the website. At Erehwon, it's a bit more complicated because we have both a wired and wireless network that they can connect through.
Now, you mentioned earlier that Principal Thompson asked you to investigate Ms. Leslie's blog. What were you looking for in that investigation?
I really had 4 goals. The first was to determine who actually created the blog. The second was to determine where the blog was created. The third was to determine any type of usage figures that might potentially pertain to the blog. And then finally, I looked at any trends over time at which the blog may have been used.
Now, the first step you mentioned was determining who created the blog. What did you find in that regard?
Objection, Your Honor, as to hearsay and lack of foundation. Pursuant to hearsay, Evidence Rule 802, the research Mr. Dell conducted is an out-of-court statement being offered today to prove the truth of the matter asserted. As pursuant to Evidence Rule 702, there is lack of foundation for this witness to testify as to this expert testimony. Under Evidence Rule 702, testimony of an expert nature has to be based on reliable scientific, technical, or other specialized information. No testimony has been elicited to demonstrate how Mr. Dell went about conducting this research, and as we know, it is based upon hearsay to begin with.
Your Honor, may I respond?
Yes.
Your Honor, pursuant to Rule 801C, hearsay is defined as a statement made by a person other than the declarant testifying in court, offered for its truth. In this case, Mr. Dell is not testifying to any statements anyone made outside of court, but rather he is testifying to the results of an investigation that he himself conducted. And in response to the objection regarding expertise, this court has already certified Mr. Dell pursuant to Rule 702 and all of the accompanying factors and components of Rule 702 as an expert. And because he is an expert, he may testify to the results of an investigation that he conducted.
May I be heard, Judge Coe?
Objection is overruled. You may proceed.
Yes, Your Honor. Okay, now you mentioned that the first step of your investigation was to determine who created the blog. What did you find in that regard?
I was able to determine that the blog was in fact created by Alex Leslie based on 2 different pieces of information.
What were those pieces of information?
The first was that when I looked at the blog itself, the handle of the person that created the blog was the Alex, which is a reference to Alex Leslie. The second piece of information is that when I examined Alex Leslie's school email account, I was able to determine that she in fact sent an email from that account to several other students' accounts in which she asked them to view the blog.
Objection, Your Honor, as to hearsay, in fact, double hearsay. The email itself is hearsay, and then the statement within the email that Alex Leslie encouraged students to access the blog is also hearsay. And hearsay is defined not only as an out-of-court statement verbally, but as a written or oral assertion pursuant to Evidence Rule 801A.
Your Honor, may I respond?
Yes.
Your Honor, the fact of an email's existence does not qualify it as hearsay. However, to the extent that this court would consider the contents of that email to be hearsay, it is admissible under Rule 803B3 as it is a statement against interest. Therefore, it is admissible.
Your Honor, there is no Rule 803B3 in the evidence rules, Your Honor.
Your Honor, I apologize. I meant 804B3. My apology.
Well, regardless, the objection is overruled. You may proceed with your examination.
Now, you mentioned that in that email, Alex Leslie asked students to access her blog. Did you find that those students ended up accessing her blog?
I was able to trace several of the students who received the emails, computers, to actually accessing the blog from Professor Clark's class.
When you say Professor Clark, is that the same Professor Clark that testified here today?
It is, in fact.
Now, Mr. Dell, the second step of your investigation was that you wanted to see where the blog was created. What did you find in that regard?
I was able to conclusively determine that the blog was not created on the school's computer network, but beyond that, I'm not sure.
Well, the third step you mentioned was that you wanted to determine any usage patterns. What did you find in that regard?
Well, when I looked at usage patterns, I looked at the two components of the school's network separately, both the wired and the wireless. Which one would you like me to talk about?
Can we start with the with the wired network?
Sure. On the wired network, there was a total of 50 hours of access to the blog. That is, people were actively looking at it for 50 hours, over 200 separate access incidents since the blog's inception.
Now, you mentioned that you examined the wireless network. What did you find in that regard?
On the wireless network, there was a further 100 hours of access over another 300 separate instances of access.
Now, the fourth step you mentioned was that you wanted to determine any operational trends based on what you perform at Erehwon. What, if anything, did you find in that regard?
I really found two major trends. The first was that about half of the total access to the blog occurred during Professor Lee's class periods. The second was that the blog was accessed at a fairly consistent level since its inception before undergoing an easily identifiable increase during the first week of November.
Now, Mr. Dell, what did you do upon conclusion of your investigation?
I compiled a report and took it to Principal Thompson for discussion.
What did you discuss?
We discussed my results, and eventually we determined that it would be best to block the blog from the school's computer.
Objection, Your Honor. This discussion, which Mr. Dell had with Principal Thompson, is an out-of-court statement being used to prove the truth of the matter asserted.
Your Honor, may I respond?
Yes.
Your Honor, pursuant to Rule 801C, this testimony is not being offered for its truth, merely as to the foundation of steps that Mr. Dell later took, and thus is not being offered for its truth.
At this time, the objection is overruled.
So what did you do after your discussion with Principal Thompson?
Well, at that point, I followed Principal Thompson's orders, and I blocked the blog, which required me to shut down the school's network for about a half a day.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Judge Cupp. May I proceed?
Please.
You work for Erehwon Local School District, correct?
I do.
You're the Director of Information Technology.
I am.
And you're paid for your job?
Of course I am. I don't work for free.
Certainly. I wouldn't blame you. So, Erehwon Local School District pays your salary, though?
Well, right, obviously.
And you even went to school at Erehwon, correct?
I did. I went to high school and graduated from Erehwon High School, actually.
And you interned at Erehwon High School?
Over the summer of one of my, during college, yes.
During direct examination, in fact, you said that you jumped at the opportunity to return to Erehwon, right?
I did. My family's here, and so it just seemed like it'd be a nice place to move back to after Atlanta.
As you said during direct, Erehwon's your hometown.
It is.
So you like Erehwon?
It's a nice town. It's small, doesn't have the crime problems that some bigger cities do, and yet it's still got a nice feel to it.
You were qualified as an expert in data retrieval and computer systems administration. Did I write that down correctly?
I believe so.
Nevertheless, you weren't qualified as an expert in statistics, were you?
Statistics? No.
Okay. Nevertheless, you cited a lot of statistics during direct examination, correct?
I don't believe that I did.
You don't believe that you cited any statistics during direct examination, Mr. Dell?
No, I didn't.
Well, nevertheless, you conducted research on the plaintiff's blog, correct?
I did.
And Principal Thompson ordered you to conduct this research?
She did.
You provided information to Principal Thompson after conducting this research, correct?
Correct. I compiled a report and talked to her about it.
In her opening statement, Ms. Gupta claimed that the defense would prove that a substantial disruption occurred as a result of the plaintiff's blog. You provided this information to Principal Thompson, and as a result of your information, Principal Thompson decided to turn off the internet because he believed a disruption occurred.
No, Principal Thompson decided to block the blog. Turning off the internet was a necessary consequence of that.
Okay, so nevertheless, though, Principal Thompson did turn off the internet to block the blog.
Well, I turned off the internet, but it was, again, a consequence of blocking the blog, yes.
Okay, Principal Thompson relied on your information in making this decision, right?
I would assume so.
He relied on your opinion as well as the data that you had retrieved, correct?
I really didn't have any opinion. Everything was statistical.
Okay, everything was, I thought you didn't get any statistics during your research. That's just what you testified.
You're right, excuse me. I provided quite a few numbers, but I wasn't looking at any particular statistical analysis of how the blog may have been accessed.
All right, so your testimony is still that you didn't do any statistical analysis?
Correct.
Okay, just to clear that up. The integrity of the principal's ultimate decision to turn off the internet and block the plaintiff's blog is at least somewhat dependent upon the information you provided him, correct?
Again, I would assume so, but I'm not Principal Thompson.
All right, let's go through this information then that you provided him.
Of course.
Now, during direct examination, you said that there were two main areas you looked into, right? First, wired and wireless. I wrote this down, sir.
You mean the two separate parts of the computer network?
Yes, exactly, sir. You claimed some things with regards to the number of hours students spent on the plaintiff's blog, correct?
There was a total of 150 hours of access, yes.
Exactly, I wrote that down. First, that there were 50 hours spent on the wired access.
Correct.
And there were 100 hours, did I get that right, on the wireless?
That is correct.
Okay. You weren't physically there for the 50 hours you claimed students were accessing it from the wired network, were you?
I have records of it.
But you weren't physically there watching the students, were you?
No, I don't need to be. That's the point of a record.
You weren't physically there watching the students when you claim that they viewed it from the wireless network.
Well, I know that they viewed it from the wireless network, but no, I wasn't there.
So your answer is yes, you weren't physically there watching them.
That is correct.
Okay. And again, it's your testimony in court that these numbers, these aren't statistics.
No, again, they're a simple number.
They're just simple numbers. Okay. Now, you also claim some things with regards, a student could have logged onto the blog and left his computer on while he went and had lunch, correct?
No, actually, that's impossible. The computer logs actually log active access to the blog. That is, when the student's computer is communicating with the server that hosts the blog, it's actively sending information between the two. That is, when you're scrolling up and down, it needs to load more parts of the page. If the student's not actually moving the blog or doing anything with the blog, then it's not counting the access.
Objection, Your Honor, as to invention of fact. Everything that the witness just testified to is not contained within his witness statement, and it materially affects the outcome of the case. As you know, witnesses are not permitted to extrapolate during cross-examination unless it is fair and neutral, which that is absolutely not fair and neutral, as it goes directly to the Tinker standard regarding substantial disruption.
Your Honor, may I respond?
Response.
Your Honor, on cross-examination, extrapolation is in fact permitted, and this extrapolation was called for by the question asked on cross-examination. Mr. Dell was merely pontificating upon his point of his research and his investigation, which has been admitted into evidence thus far in the hearing.
May I briefly respond, Your Honor?
I think it was near the limit of the rule, if not past the rule. I'm going to sustain the objection to that.
Move to strike the witness's answer, Your Honor.
To strike the last answer.
Would you please instruct the witness to answer my question?
I think the witness probably understands.
Okay. I'll ask again then. Mr. Dell, a student could have logged onto the blog and left it on his computer screen while he went and ate lunch, right?
He could have done that, yes.
A student could have logged onto the blog and left it on the computer screen while he went and asked a teacher for help, right?
He could have, but again, it wouldn't be part of the record.
Okay. Now, you also claim some things, and I wrote these down, with regards to the number of accesses students made to the blog, right?
Well, yes.
Again, in the wired and then wireless areas, right?
Correct.
First, that it was accessed for approximately 200 times from the wired network.
And a further 300 from the wireless, yes.
All right, good. So I wrote that down as well, too. 300 accesses from the wireless.
You're correct there.
Okay. Alex's blog had educational notes on it, didn't it?
I'm not sure.
You're not sure? You conducted research into this blog. Didn't you read the blog?
When I read the blog, there was links to notes, but they would be on a separate page. They're not part of the blog.
Okay, so when you researched the blog, you just only looked at what was physically there. You never delved into the actual notes.
Again, the notes weren't part of the blog, so no.
Okay. Now, you never identify how many times a particular student might have accessed the blog, correct?
A particular student?
Yeah.
No, I didn't break it down by student.
It's possible the same student could have gotten on that blog 20 times to check the notes that were posted there that you didn't read.
Objection. Question calls for speculation.
May I be heard, Your Honor?
Yes.
Pursuant to Evidence Rule 703, witnesses that are qualified as experts are allowed to respond to hypothetical situations, which is exactly what I'm posing to this witness. I'm challenging his credibility and his expertise, which I requested permission to do so.
Your Honor, may I respond?
The objection is going to be overruled. You may proceed. The witness can answer if he knows.
It's possible the same student could have accessed Alex's blog 20 times to check the educational notes you didn't read, correct?
They wouldn't be included in any of the usage figures that I provided because, again, the notes are not part of the blog, but it is theoretically possible, yes.
So the answer is yes, it's theoretically possible.
Theoretically possible, but it wouldn't be included in any of my figures.
All right, so basically, Mr. Dell, despite these numbers, you couldn't tell Principal Thompson and you can't tell Judge Cupp whether a student spent 1 hour or 20 hours physically reading this blog.
I'm sorry, could you explain what you mean? I'm not
Despite
sure I
these
understand
numbers, you can't tell Judge Cupp whether a student spent physically sitting in front of his computer, physically reading the blog for 20 hours or just 1 hour, can you?
Well, if you take the simple number of accesses, 500, and you divide it by the 150 hours, you get an average of the amount of time that a student would spend accessing it. It's possible that one would access it that way, but again, the averages show that on average there's about 15 to 20 minutes.
All right, so you have to do the averages, though. You can't say anything for sure. A student could have been on that blog for 20 hours. You don't know that.
Again, common sense would dictate that if there's 500 accesses over 150 hours, that not all of them are going to be 20 hours long.
Regardless, sir, yes or no, a student could have spent 20 hours on that blog.
Again, it's theoretically possible, but clearly it wouldn't make sense.
Okay, regardless of these numbers, you can't tell Judge Cupp whether a total of 20 students or 30 students physically accessed this blog.
Again, it wouldn't make sense for just such a small number given the amount of accesses.
Sir, I'm not asking you what makes sense. I'm just saying you can't tell Judge Cupp that, can you?
I didn't break it down by students, no.
So that's a yes. You can't tell Judge Cupp that.
That is correct.
Okay. Despite these numbers, you can't tell Judge Cupp whether a student accessed the blog 1 time or 20 times, can you? The same particular student.
Objection. Asked and answered.
Sustained.
Your Honor, I have no further questions at this time.
Redirect.
Yes, Your Honor. May I proceed, Your Honor?
Please.
Mr. Dell, on cross-examination, opposing counsel asked you about your affiliation with Erehwon. Do you recall that line of questioning?
I do.
And did your affiliation with the school at all impact your investigation?
No. As I'm employed by the school board and not by the principal, she wasn't technically my superior.
Were any of the numbers that you provided by Principal Thompson influenced with your relationship with the school?
No, they're numbers. You can't just make up a number.
Lastly, Mr. Dell, on cross-examination, opposing counsel asked you about the notes present on the blog. Do you recall that line of questioning?
I do.
And from your investigation, did you find any evidence of students accessing the blog's notes?
There was no evidence of any access to the
Your
blog's
Honor,
notes.
invention of fact, as well as outside the scope of my cross-examination, but specifically invention of fact, nowhere in the witness's statement does it say he has no evidence that students viewed Alex's notes. In fact, you heard quite the contrary from Alex herself when she testified.
Your Honor, may I respond?
Yes.
Your Honor, the standard for submitting an affidavit in this case is that one must include all relevant and material facts to this case. If students were accessing Ms. Leslie's blog for her notes, that would be a relevant and material fact and would be present in the affidavit. The absence of that fact indicates that it didn't occur. And as you heard Mr. Dell testify earlier, he examined specifically the blog and not any links attached to the blog. So therefore, this is not at all an extrapolation and is permissible.
Your Honor, it's not contained within the statement, and as Mr. Dupuy himself said, Mr. Dell didn't look into that. So
I'm going to sustain the objection as to the form of the answer, but you may re-ask the question.
Move to strike the witness's answer, Judge Cupp.
Granted.
Thank you.
Mr. Dell, did you analyze any links that were contained within the blog?
I did.
Did you analyze the links that the notes led to at all?
I looked at them, yes.
And from your investigation, did anyone anyone on the blog access those links?
Objection, Your Honor. You've already ruled on this very issue. It is an invention of fact, and it's not contained within the witness's statement that he would be able to testify to this question.
Your Honor, may I respond?
Yes.
Your Honor, the objection was sustained in regards to the question, in regards to the answer, but not the question. This objection would only be properly raised depending upon Mr. Dell's answer to this question.
Your Honor, I'd be more than willing to wait for his answer, but if it goes beyond the scope of his witness statement, I will object again.
Objection's overruled.
Mr. Dell, did you provide the court with any information in your affidavit that would suggest that you saw students accessing the notes in the blog?
No, because I didn't find any evidence of it.
Thank you. No further
Objection,
questions.
Your Honor, as to the final part of his answer, not the first part, but the final part that he found no evidence of it, that is an invention of fact. It is not contained within the witness's statement.
Again, Your Honor, the foundation was laid that he did not notice any students accessing the blog. That was a mere follow-up to his answer, and is thus permissible.
Objection's overruled.
No further
Proceed.
questions, Your Honor.
All right.
No recross, Your Honor.
Witness will be excused. Does that conclude the defense testimony?
Yes, Your Honor. The defense rests.
All right. The counsel will be given 2 minutes while the court stands in recess in place for preparation for closing argument.
Yes, Your Honor.
Wow, good arguments on both sides. Once again, you're watching the 2010 Ohio High School Mock Trial Championship, coordinated by the Ohio Center for Law-Related Education. We're coming to you from the State House here in downtown Columbus. Right now, the students have a couple of minutes to prepare their closing arguments. After that, the judges will adjourn for a short while to deliberate, during which time I'll have a chance to talk with some of the students participating today and get some of their perspectives. When the judges are finished deliberating, they will then come back in and announce the winning team. But first, we're going to go back to the floor to hear some of the closing arguments. All right. Plaintiff's counsel ready for closing arguments?
Yes, Judge Cupp.
You may proceed when you're ready.
May it please the court, there was only one issue before the court today: whether Erehwon Local School District is liable for violating Alex's First Amendment rights when it severely punished her for educational speech she published with the help of her own mother on her own time in her own home. There were 5 facts which Ms. Schwab said in her opening would prove, and they are now undisputed. First, from Alex herself, you heard that 1, her blog was created from within her own home, and 2, served an educational purpose. Then from educational expert Dana Clark, you heard 3, any disruption was caused by Principal Thompson's overreaction. 4, the severity of Alex's punishment was a disproportional response. And 5, this overly severe punishment has already had a chilling effect on student speech. Now, Your Honor, the defense has alleged through the testimony of their witnesses today that the content of Alex's blog was vulgar and profane. However, that is irrelevant to the case at bar for 2 reasons. First, all of these comments were posted from within her own home. And second, that has nothing to do with the standard that the court is bound to apply to this case, that of Tinker v. Des Moines. In 1969, the United States Supreme Court held that schools lack the authority to punish students for speech that did not cause a substantial disruption, and that a school could not punish students for wearing black armbands in protest of the Vietnam War. That has nothing to do with vulgarity or obscenity or the content of speech, but rather disruption. Now, Your Honor, in the modern day, there isn't just speech within schools anymore. There's also speech on the internet in realms outside of the school's jurisdiction. And the Tinker standard must be applied to this speech as well. In Layshock v. Hermitage School District, that's exactly what the court did. In Layshock, the court held that a school lacked the authority to regulate off-campus speech. In Layshock, a student posted on a website that she created, strictly insulting her teacher, attacking her teacher, nothing of any educational purpose, like the plaintiff's blog, but yet the school still lacked the authority to punish the student. Your Honor, in Layshock, the disruption that occurred, 5 teachers called the principal to complain about the student's website. Multiple classes were canceled. The principal had to spend 25% of her time responding to the student's website. Your Honor, that didn't even rise to the level of substantial disruption according to the court. So much more so does this case not meet the level of substantial disruption. You heard from Mr. Dell that he can't even interpret his own statistics. He can't tell you whether a student spent 1 hour or 20 hours on the blog. He can't tell you how many students accessed it. And Professor Lee spent the majority of her testimony complaining about the content of Alex's blog and Alex's actions within class. Well, Alex's actions within class should have been handled by Professor Lee during class. It had nothing to do with the plaintiff's blog, Your Honor. Furthermore, more importantly, the key fact at issue in today's case is that the actions of the school, the overly severe punishment, had a chilling effect on student speech. You heard from Professor Lee testify that the content of the blog was offensive, that the plaintiff called her a jerk and SOB, that, well, expletive that and expletive Lee. Your Honor, these comments were posted outside of the classroom, and just because Professor Lee doesn't like it doesn't mean that the school can extend its arm of authority to punish Alex. In fact, I challenge Mr. Dupuy in his closing argument to cite any case in which a school had the authority to regulate off-campus educational speech. I'm confident he will be unable to do so. You heard from Ms. Clark that the overly severe punishment was only intended to cause a deterrent effect on student speech, and that's exactly what happened. You heard from the cross-examination of Professor Lee, students asked fewer questions. They made fewer comments. They were scared to death because they were worried that they would be suspended as well. Your Honor, at the end of the day, the facts of this case are clear. A man's home is his castle. A school can, in some limited circumstances, control speech from within its own campus, but it cannot control speech from the sanctity of our own homes, let alone punish us for it. To rule in the defense's favor would be to affirm the belief that schools have the authority to become arbiters of not only the classroom, but the internet, the neighborhood, the soapbox in a local park, and yes, even our own homes. Such a chilling effect is directly contrary to our country's ideals and flies in the face of both the literal and aspirational meaning of the First Amendment. Therefore, we respectfully request that you rule in Alex's favor, because at the end of the day, the government has never and should never be allowed to come into our homes and tell us what to think and not to think, and even, Your Honor, who to like and dislike. Thank you.
Defense may proceed with your closing argument.
Permission to stray from the podium, Your Honor.
Granted.
May it please the court. It is the responsibility of American public schools to prepare its youth to become citizens of our republic. In accordance with this principle, schools have granted broad deference to school administrators on how best to run their schools. Now, in today's case, we must balance the responsibility of Erehwon High School to provide a safe and conducive educational atmosphere with Alex Leslie's alleged right to speak out and incite disruption within the classroom from her home. In every analysis regarding school speech, the court has looked at whether or not the speech was related to school or not. Now, opposing counsel's argument today was that a home is a castle and that we may not penetrate the castle. However, the wall and the gates separating Alex Leslie's castle or her blog and the schools was shut down and closed, and opened, in fact, when Alex Leslie targeted Professor Lee and the classroom in the events that were occurring in the classroom. That barrier between the castle and the school vanished completely due to Alex Leslie's own actions. Now, in his closing, opposing counsel cited Layshock versus Hermitage in stating that schools may not censor off-campus speech. However, even in that analysis, the court recognized that it was, quote, a close call, and the standard set forth in that case was tested yet again in Blue Mountain School District versus Snyder. In that case, a student talked about a principal in the school, insulted him personally, and criticized his methods and his abilities. She invited other students to rant on her online location website. And in that case, the court ruled that not only was it school-related, but it was vulgar and obscene enough and disruptive enough to merit being punished and restricted by the school. In this case, Alex Leslie herself testified that she intended her blog to be read by students and that she knew they were reading it. Not only were students approaching her and thanking her, but she stated herself that it seemed like everyone at school was talking about her blog and that everyone had accessed it at one point or another. Thus, we can see that this speech is clearly school-related, and the only argument the plaintiff has put forth today falls. Now that we have now that we have shown that the plaintiff has failed to meet its burden in showing that it was not school-related, two other things will be shown. First, that Alex Leslie's blog was vulgar and profane, and for that reason merited restriction. In Bethel versus Fraser, the Supreme Court recognized that lewd, vulgar, and obscene speech was not protected. Alex Leslie herself called Professor Lee an unimaginative jerk, an SOB, and in fact stated expletive that and expletive Lee. In fact, not only did she merely use vulgarities, but she criticized and insulted Professor Lee on her blog, thus rising above the standard set forth in Bethel versus Fraser. And as the court noted in Chaplinsky, speech like that of Alex Leslie's blog has absolutely no societal benefit and thus has absolutely no protection under the First Amendment. And the last issue today is that the plaintiff has failed to show that Alex Leslie's blog did not cause a substantial disruption. In Tinker versus Des Moines, the court ruled that a substantial disruption must occur in school if the school wishes to restrict off-campus speech. In that case, they also noted that it is not the responsibility of American schools to surrender their control to American public school students. In fact, the plaintiff cited a chilling case taken from Granville versus Thomas. However, that court noted that it was possible to incite a substantial disruption from a remote locale. Not only did Alex Leslie testify before you today that students were asking more questions and following her orders, but access to this blog occurred in Professor Clark's own classroom. You heard from Professor Lee that every time Miss Leslie asked students to ignore Professor Lee, to act out and disrupt the class, that's exactly what occurred in class. Students were cutting her off, asking irrelevant questions, and making irrelevant comments so frequently that she herself, the authority figure in the classroom, was unable to control their very behavior. A teacher that has been teaching for 18 years could not control it. It was so disruptive. However, this disruption wasn't confined merely to Miss Lee's class. As you heard from Ken Odell, this blog had been accessed over 500 times for a total of 150 hours during that first week of November, which is far more than can be tolerated by this court or by the school. And thus, since the gate of the castle of Alex Leslie's home was opened and her speech ravaged inside the school and caused disruption, we respectfully request that you find in favor of Erehwon High School today. Thank you.
Thank you, counsel. Is there a rebuttal? Certainly, Your Honor. You may proceed.
May I proceed, Your Honor?
Yes.
First and foremost, Mr. Dupuy did not meet my challenge of citing any case in which a school had the authority to regulate off-campus educational speech. And that's exactly what is at issue in today's case. You heard from Alex. Every substantive blog post that she made contained notes. This is educational speech that is beyond the authority of the school to regulate. Now, Mr. Dupuy did cite two cases during his closing argument. The first was Bethel v. Frazier, which he used to argue that the content of Alex's blog was vulgar and profane. Your Honor, in Bethel v. Frazier, a student gave a sexually explicit speech to a crowd of students who were mandated to listen to that speech. They were required to. This is freshmen, sophomores, juniors, and seniors, a captive audience, listening to sexually explicit satire. Your Honor, where on this blog did Alex use sexually explicit satire? She didn't, nor did she have a captive audience. She didn't post this on school grounds like the speech was in Bethel. Now, he also cited Snyder v. Blue Mountain School District. Your Honor, in that case, a student posted defamation, libelous comments to an online website, comments that were illegal. None of the comments on this blog are illegal. Your Honor, at the end of the day, it couldn't be more simple. It's not about disruption. It's not about vulgarity. It's not about defamation or libelous comments. It's no more simple than the fact that Professor Lee didn't like what Alex posted. It violated her standard of common decency, so she wanted to restrict that speech. That is nothing more than viewpoint censorship. Your Honor, Alex Leslie is a devoted student, simply trying to learn, simply trying to express her views in the way she knows best. We're asking that you give Alex that chance. We're asking that you let her views be heard. Therefore, we respectfully request that you rule in Alex's favor and preserve her home as the castle it ought to be. Thank you.
That concludes the testimony and the argument in the case. And at this point, the scoring judges are going to retire to the deliberating room and deliberate, while I will remain 3 minutes to entertain any post-trial objections, and then I will join the other judges. Okay, you may be seated. Timekeepers, was there any discrepancy in the time?
No, Your Honor. Your Honor.
Thank you for a job well done. Does either team have serious reason to believe that a material violation of any rule has occurred during this trial? I'm going to remain here for 3 minutes, as I've indicated, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with any team members involved in this particular trial, but may not communicate in any way with legal advisors, teachers, or anyone outside the performing team members in this trial. And so I'd ask the timekeepers if you would start the 3 minutes.
Your Honor, the defense has no objections.
Right.
Your Honor, the plaintiff has no post-trial objections as well.
All right, then I guess I don't need to remain for 3 minutes, thanks to both teams. Yes, I'll wait for the time sheets. So you've got them ready there.
Very exciting. Once again, you're watching the Ohio Channel in the 2010 Ohio High School Mock Trial Championship. We're coming to you from the Ohio State House here in downtown Columbus. Today, acting on behalf of the plaintiff was Indian Hill High School of Cincinnati, and the defense was presented by Sylvania Southview High School of Toledo. Right now, the judges have retired to do their scoring, and while they're doing that, let's talk a little bit about the case. This year's case ventures into the area of the First Amendment to the United States Constitution. Once again, I have with me Lisa Eshelman to help me explain what we've been watching. Okay, just to set things straight, are we actually going to hear a ruling on the case? Will we know the outcome of this case?
Absolutely. The justices are back deliberating right now. They are going to reach a decision as to which team won and which team lost.
Now, it is which team won or which team lost by the basis of the argument. So, in a sense, we'll hear the conclusion of this argument by the announcement of the winner of that case.
That is exactly what's going to happen in just a very few minutes.
Now, can you just tell us some of the highlights that you saw might have been really strategically good ideas or problems with any of the arguments?
Absolutely. First of all, it was an extremely hard-fought trial, exactly what we would expect to see in a state competition. What I thought was particularly good on both sides were that they had a very clear theory of the case. You may remember on behalf of Alex Leslie, their theme throughout the trial was a man's castle, that Alex Leslie had the right to be a man of its own castle, and that the school didn't have any right to come into that castle in order to regulate the free speech. On the other hand, I thought the school district did a great job of articulating that the balance that there must be to First Amendment, that the schools are given great discretion and they have a huge responsibility to educate students, and therefore the law gives them the opportunity to put limits on certain kinds of speech of students. And I think you heard in the closing argument on behalf of the school, they turned that man in his castle around a little bit and said, certainly a person has a right to their own castle, but when Alex Leslie opened that gate, so to speak, and let that free speech through, then it became the responsibility of the school to regulate that speech. And I thought that was very effectively well done by both sides.
Now, the teams that are here, they've had a lot of training and they're very experienced with the various topics. But does the topical matter, for instance, blogging about your feelings about a teacher, do you think that changes the passion to which the teams may take a subject versus maybe a more esoteric subject that has perhaps appeared in the past?
Well, I think especially for this case, this is the type of topic that students deal with every single day. So it is something with which they're very familiar. It's probably the topic that they have many opinions about. It relates and resonates with what they do every single day. So they begin to think, do I want someone to be able to look at and regulate what I have to say? Or am I more in the position where my free speech rights ought to take priority over something else?
Now, what's interesting about this, it draws you into the various issues that happen every day in our courts because you can see both sides of the argument. And so this serves as a very valuable learning tool. Now, how much of what the students are saying is pre-prepared versus how much are they actually making the argument while this is going on?
Well, certainly parts of the trial, like the opening statement, the direct examination of their own witnesses, and the initial closing arguments are areas of the trial that students have spent a lot of time preparing. Where their advocacy skills really come in are the things such as the cross-examination of each witness. Certainly they have prepared a general outline of the types and topics that they want to perform a cross-examination on, but those lawyers have to be ready to respond to anything that comes up from the other side. And we saw examples from each of the four witnesses where the lawyers were required to respond directly to something that was said on direct examination.
Okay, and this is also a kind of a technical question. Do we have the plaintiff and the defense? Now, do they know which side is going to be the plaintiff or defense coming into this, or is that chosen through a coin toss, or how is that determined?
That was chosen last night at the conclusion of the semifinal rounds, and I believe it was done by a coin toss.
Now, when a team comes, so we have Indian Hill and then Sylvania. When they come with both a plaintiff and defense team, or will the team have to switch gears in whether or not they're the plaintiff or defense?
Most schools come with both a plaintiff and a defense team. That allows more opportunity for students to participate. And so depending upon how that team advances through the competition, you might have one of those teams that don't get this far.
This is an unfair question, but do you think of, and the students are standing right over there, do you see a clear winner yet?
I think I do, but that's why we have judges. And so we're going to let the judges decide this one and not just me.
Okay, well, thank you very much for your insight in this, and I'm looking forward to seeing this again next year.
So am I.
Okay, great, thank you. And right now we also have some students that we just saw here very deftly arguing. So this is Indian Hill, right, and your name?
Brittany Schwab.
Danny Strunk.
Danny, I recognize you from last year.
Yes, I'm back again defending the title. So
Now, did you play the same role last year?
last year I was a double closer. I closed for the defense and plaintiff, and this year I'm a double closer again. So more of the same, but it always challenges you in new ways. It's a completely different case. So
This is, 60, 90 seconds after you just made your closing argument. How do you feel right now?
Well, I'm on like cloud nine. It's an unbelievable experience. Win or lose, this is so much fun. Just being here and doing this on television, it's fantastic. Sylvania Southview was an unbelievable opponent. They put up a really good fight. I could see it going either way. Mr. Dupuis, Ms. Gupta, fantastic attorneys. You couldn't ask for better opponents in the final round.
Brittany, how about you? How do you feel?
It very well could have gone either way. They were a great opponent by far. I would say the best we've had so far. I could see it going either way, but I'm confident in us, so we'll find out.
Now, did anything shake you out there? Did it kind of freak you out? Was there a surprise or?
Well, there are always surprises with any trial because it's never the same with the different witnesses and stuff. The witness I crossed, Professor Lee, was very good, so that was a challenge, but
she's being humble. That was the first time she ever had to cross that witness during competition, so she's being she did a great job for having done it the first time.
Now, I understand that none of you are attorneys.
Not yet.
Not
quite
not yet. So, what was it like up there with the objections and stuff? Did it stump you? Were you ever in a moment of like, oh no, what's going on?
I mean, I love it. I think it's so much fun. It's so much fun to think on your feet, and we've done a lot of preparation, and you can tell that Sylvania Southview has done it too. So
yeah.
We're ready.
It's a blast. Usually I suffer from having too much to say, not too little to say. So it's always a blast. Always good, clean fun.
So, Danny, compared to last year's topic, which I believe was
equal protection.
Soccer.
Yeah.
Yes.
Mm-hmm.
So, and your witness was a soccer player. That was.
It was very similar. I directed a student last year who was being punished for something that she couldn't control, and similar situation and same witness playing the part. So it was a natural evolution to a different area of the Constitution. Last year was 14th Amendment. This year's First Amendment. So.
But this year's topic seems particularly apropos in that this is stuff that's actually going on right now. A question of when is it public and private, and when is it part of the school? How did you feel about that?
Well, I thought it was an interesting issue. I think the Supreme Court is kind of the law isn't exactly well settled yet on what schools can do with regards to off-campus online speech, and I think if I can make a prediction in the coming years, I think we're going to have a United States Supreme Court case that's going to probably delve into this area. So,
do you have a blog?
No, I do not. I do not have a blog.
Do you have a mean AP English or a history teacher?
All my teachers are unbelievable, so I have no reason to complain about any of my teachers.
What grade are you right now?
I'm a senior.
Oh, you have to say that, man. It's just a couple of weeks.
Well, no,
right?
I don't necessarily. Well, yeah, I do.
There you go. What are your plans, Danny?
College. Don't know where yet. I get news back. Hopefully by April 1st, I believe I hear back from all the colleges I've applied to.
So what's your career path as of right now?
Well, I plan on going into law. And then I would hope to one day be a federal judge. Knock on wood. That's the goal. That's the dream.
There you go. Nice trajectory.
Mhm.
Brittany, what about you? What year are you?
I'm a senior as well.
Okay, so yes, say the right things, right?
Exactly.
And then what are your plans after graduation?
I was actually accepted early decision to Colgate University, so I will be going to Colgate next year. Hopefully I'll be doing mock trial there as well, so that should be a lot of fun. I eventually also plan to go into law like Danny. So.
Yeah.
Wow. So do you plan on coming back for mock trial and helping out using your strategic defenses?
Absolutely.
Offenses and everything you've learned. Well, thank you. You guys did a great job, and thank you. I guess I won't see you next year, but good luck, and I hope I don't see you in court. So
Thank you.
Thank you very much.
Thank
you very
you.
much.
Okay. And now we have Sylvania High School here. And your name?
Would you like the English version or the real version?
Give me the real version.
Smriti Gupta.
Smriti?
Smriti.
Smriti. Okay. We'll just have to. I want you standing here a little bit closer. And you're Clement.
Yeah, I go by Clay though. So
Clay.
it's even
Okay. So, what do you think now? It's been a couple of minutes since you just had to give your closing presentation, and how do you feel?
I thought the whole round was really tough. I thought, the closings were. I thought his closing was excellent, and it was a battle right to the last minute. So I thought, I'm really proud, win or lose. I'm just glad we made it here, So I thought it was all good.
And how do you feel?
I feel like, honestly, it could go either way. Both the teams had really strong witnesses, strong crosses. It's going to come down to the judge's preference.
So was there anything that was going on out there that there was a surprise to you, or did you feel like yay or like, oh no?
Surprises pop up occasionally. We haven't faced too many teams that call the witnesses that we usually call on our plaintiffs, so every time we've had to adjust a little bit on our backup crosses, but to my recollection, there's nothing really huge.
Was there more objections in this case than you've had in the past, or are you kind of used to those things?
I don't know. It varies between what the witness says. If the witness tends to go out more and say more, then there's more room for objections.
So you felt that it was pretty much standard to what's happened before in the past?
Yeah.
So, what are your plans? What year are you right now?
I am currently a sophomore.
You're a sophomore, so you could do this 3 more years, right?
Yep.
Yes, so you can carry your knowledge and pass it on. Do you have any plans? Are you thinking that far in advance?
As far as high school or college?
At college and then career.
Attorney. Being an attorney is one of my options that I'm looking at. Hopefully, I'll get into a good school and can pursue that.
Yes, and this is really good. I would imagine that probably most of you are probably looking to be an attorney. What about you, Clay?
Well, to be honest, right now all I'm thinking about is going home and eating. But as far as careers go, I'm definitely considering something in the legal aspect, because I figure if I can just do mock trial for a living, that'd be pretty fun. But I know it's pretty different in the real world, so I'm not too sure.
What grade are you in right now?
I'm a sophomore as well.
So so not only both of you were debating against the seniors,
Yep.
so people with 3 more years of experience.
Well, to be honest, our whole team right now is comprised of sophomores, and this whole season has been nothing but you're talking about surprises earlier, and maybe not necessarily in a courtroom, but time after time, award after award, round after round. We've just been blasted with surprises. No one ever thought that we'd make it this far. So, I'm pretty happy for the team and everything. So, for sure.
A March surprise, perhaps.
Yeah,
right?
we'll see.
What do you do to prepare? How do you get yourself ready for this?
When it comes to preparing for something like this, there's not really much other people can do for you. You can have a coach, tell you about objections, teach you about maybe the law. But when you prepare, it's just you have to be mentally motivated, and you've got to do what you want to do. So me personally, I didn't call up my coach and then ask to schedule practices. I would just go home and read the case law, read the affidavits, see if I could just train myself to see those secret little details. So that's pretty much how you have to prepare, for our team at least.
Now, and then you actually don't know if you are going to be the arguing team, because you played the defense in this case.
That's right.
But it wasn't until last night that you realized you were going to be the ones that were doing this.
That's right.
And then how is that determined, whether it's going to be the defense or the plaintiff?
Well, to be honest, we walked in here, we were getting set up. We were preparing to go plaintiff. They brought in a letter. They had 2 names. They just pulled a name out and like, all right, Indian Hill, you're plaintiff. That means Southview, your defense. And I'm like, okay, so we'll just change everything up now. And that's pretty much how it happened. So that was a surprise if you want one.
Now, how much do you actually prepare in terms of like memorizing the content, knowing what was in the blog? How much did you have to prepare for that?
It's never memorization. Never, ever, ever memorization. It's just logic, flow. Like the cross-examinations, you can never memorize those questions. You just have to think, here's the witness, here's their testimony, what makes sense?
There was a moment in cross, though, with Alex, I believe, was the blogger.
Yes.
Where you were able to cite chapter and verse her statement, and she actually asked you, where did I say that? And you were able to pull that out. So that was just because you were familiar with the blog.
Well, I mean, again, with practicing, you have to go through everything, every little detail. You change, you adjust. So as I read the blog, I mean, I wasn't scrolling at the bottom page, all right, 91, talks about this, this, this. I was just reading it so many times, I became so familiar. And, that's one of the things you have to anticipate. Like, is a witness going to challenge me? And if so, I can't just, fumble around. So, that specific incident in court, I knew where that line was. But if you ask me, where did she say X, Y, Z, I'll probably be like, I don't know, anywhere.
And then, Sylvania, what about you? What did you do to prepare?
Much like Clement, I went over the case materials. I read through everything. Thought, okay, well, this is the witness I'm going to drag. This is the witness I'm going to cross. Is there any way that I can maybe integrate the information, make it seem like there's a logical flow pattern, and be able to present a theme, if you will, throughout the entire case, so it seems like there's a logical flow through the entire process and everything fits together in a puzzle, basically.
Did you get nervous?
Nerves? Honestly, I get nervous before every round, but I mean, that comes with anticipation. What side are we going to do? Who are we going to face? What's it going to be like? But once we get into the courtroom and you sit down and just think, okay, we're here, we're going to argue this, we're going to do this, that's the other team, we can do this, the nerves eventually go away.
Wow. What about you, Clay?
Not nervous at all.
Really?
Not at all. You got to come into this round and you're just focused and concentrated. I mean, it's funny, but the more pressure there is to the situation, the less you can afford to be nervous, So I just walked in this room and I was like, all right, this is what I have to do. This is what I have to review. Can't waste emotional energy, physical energy, can't be distracted at all. So for me, nervousness was not at all a problem. It's got to be confidence and concentration. That's what's going to get you through.
Well, for the both of you, these are awesome skills to have for the rest of your life. I wish I could inherit some of them. Well, good luck with everything, and I guess maybe I'll see you here next year, the year after, and the year after that. So thank you very much.
Thank you.
Okay, we have some more. Look, we have the professor and the IT guy. So, and the professor's actually, what's your name?
My real name is Brianna Cry.
Brianna, and then?
I'm Austin Mance.
Austin. So, what do you think? Cross-examination, all this stuff, and you're the mean, nasty teacher that inspired a horrible blog.
Well, I tried to play more of a victim. I mean, that's what I really tried to go for, but it was really, I tried to not go for more being being offended by the blog and more press the disruption that I saw in the class.
I was wondering, just personally, now, what year are you in school?
I'm a sophomore.
You're a sophomore, so you've got 3 more years for this work.
This year and then
Yes.
junior and senior.
2, yes, exactly. Oh, there's the math part, right? See, good analytical thinking. So when you're saying that if you were an instructor, if you were a teacher, and a student actually wrote a blog about you, how would that make you feel in real life?
Well, most teachers have, I don't know, like Clark had said in her direct, they have to develop a thick skin. And, criticism of a teacher is pretty normal in high school. I mean, I know I've been a little critical about some of my teachers before. And, well, I mean, some of the comments in the blog were pretty bad, though.
Mm-hmm.
But, I mean, just the language.
What is your background? What is your career direction? What do you want to do after you're done with high school?
Quite honestly, I have absolutely no idea. I really like to do all sorts of things. So right now I'm still trying to figure out where I want to head. I mean, I really like mock trial. I really like...
Why did you get involved with mock trial? Was it for the legal aspect or the acting aspect?
I really like the acting. I do keep learning more of the legal stuff, though, and it's getting me a little more interested in it. And I really believe that I have learned some of the legal aspects of it after having done the same case over and over and a lot of the practice.
Well, you played a very convincing professor. We were looking for the patches on your coats, just like a standard university professor or something like that. I guess the stereotype. And then Austin, what about you? How did you get involved with the program?
Well, my friend Clement actually came up to me one day and just said, hey, I've got something interesting to do, come with me. And so that's pretty much what I did.
So you're a sophomore too?
I am.
Wow.
Our entire team's sophomores, actually.
Okay, and then, which means 2 more years of this. Do you think you'll want to try out again next year?
Definitely.
And then how about, what did you feel about the merits of the case?
I thought the entire case was very good. It was very even overall. Personally, I probably would have actually picked the plaintiff side of the case, but that might just be because I'm an attorney for that side. But overall, it was a really good case.
What do you think, what are your plans right now for the future?
I'm not really sure. Originally, I wasn't really into law, but the more I do this, the more I kind of enjoy this sort of thing. So maybe I'll end up that way.
So what would you, do you get nervous while you're up there?
It kind of depends. If I'm an attorney, I'm very nervous. But if I'm a witness, for some reason, it just doesn't bother me that much. It kind of depends.
Would you, is this is your first time at state?
Yes.
So is there any hints for either of you? Is there any hints that you would tell people that are trying to figure out how to get to this spot?
Pretty much just keep practicing.
Yeah, a lot of practice.
And how do you practice? What does a practice entail?
Well, we basically get together with our attorneys. Sometimes we'll be with our instructor, and sometimes we will get together after school or during lunch, during our study halls. We'll get together at each other's houses and just practice. We practice a lot.
And when you're the attorney, a lot of times, our coach will, for instance, sometimes actually give us legal books and tell us to read them, because it gives you a better understanding of the cases, since the rules follow the real law so closely. So it's just a combination of things, really.
Do you do anything to get yourself pumped up at all, like before this? Listen to legal music, drums, bum, 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 anything like that?
I don't really.
Good night's sleep, 2 square meals.
Yeah, it's kind of difficult sometimes to eat when you're just so excited and you get nervous because you're so excited and you don't know what to do with yourself, but we kind of have to make sure that we eat so we don't pass out or anything.
Well, that's great. Well, Good luck for the both of you, and again, I hope I see you here 2 more years.
I hope so too.
Yeah.
Thank you.
Thank you.
Thank you very much.
And I recognize you from last year. You're, what's your real name?
My name's Hannah Kahn.
Hannah. And your real name?
I'm Olivia Morris.
Olivia. So are you a senior this year?
No, I'm actually a junior.
Oh, so you get to have one more year.
Hopefully, yeah. Hopefully 1 more year left in me.
And then Olivia, what about you?
I'm a senior this year.
Okay, so most of the Indian Hill team then is graduating. Mm-hmm. Are they sharing with you their knowledge and skills to be able to send yet another Indian Hill team up here?
Yeah, hopefully we'll be back again. Yes.
Now, last year you played, you were a witness.
Yeah,
right?
I played
Again.
Terry Silva last year.
Yeah, and what you were, there's a soccer thing that was
Yeah,
going on.
she was a soccer player, and she supposedly wasn't legal in the U.S., and there was this whole big thing about how they wouldn't let her play soccer because of that.
I just want to play.
Yeah,
So this year you were a little bit more aggressive.
A little bit, yeah.
And writing these nasty blogs about your teacher.
Which I would never actually do.
Oh, that's right. You want to be able to graduate, actually, and walk.
Yes.
Now, I do have a question, because it is interesting in that, I think the topics are really good. But this year was truly a case where I'm like, this is a very poignant topic, and you could really see both sides. And you having to play the actual person who did the blog, how do you feel about if this actually went up, like a classmate, for instance, did something like this?
I don't know, because, like you said, I can definitely see both sides of it. And actually, we found a newspaper clipping of a case recently that was literally the exact same case. So I'm not sure how I'd feel about it. I'd probably have to look at kind of all the evidence and basically like what we do here. So.
Well, it is interesting because that, with Facebook and all social media right now, it's, your generation is really setting precedent.
Yes.
So it's not
we are.
unlikely that this very case could be heard actually at the Ohio Supreme Court, possibly eventually. Now, what is your direction? What do you want to do?
For a career?
Yeah.
I don't know. I think I told you last year. I feel like it. I'm still between law and medicine. Not really sure which way I'm going.
Not
two
acting.
very different areas, but
Both having a technical, analytical, but yet a creative approach to that.
yes, I'm very creative, so.
So you don't want to do the acting thing?
No, actually, you might want to ask her about that, though, because she's got some pretty exciting news, so.
Oh, boy.
Yeah, I am an actress, and I really do enjoy acting. I hope to pursue it in college. I also like the production side, so behind the camera work.
Yeah, it's good when you know both sides, because when you're not working in one area, you can work in the other.
Right, it's a lot of fun.
Yes. You should look us up. Public Broadcasting is always looking for good people. Where are you going to go to school?
I think I'm going to NYU.
Oh, well,
So
there
it'll be kind of fun. I did. You know, college decisions are always changing.
Now, what about the merits of the case? What did you feel personally about what was going on?
Well, it really depends on from the evidence, from what they provided, and the actual production of it. I thought from the evidence, I thought it was very well balanced. It was pretty fair. But just from this trial, I think that it was a great trial. Sylvania was
amazing.
Very remarkable. It was by far the best team we faced. I thought it was very, very fair.
So did you guys get nervous at all?
Yes.
A little bit.
I'm going to say yes. But I think both of us use that nervous energy as, excitement.
Yeah.
We both just get so excited. We love it.
Is it harder to be witnesses because you don't know exactly what's going to be asked and crossed, as opposed to being an attorney when you kind of have the idea of what you're going to say, or does that not really?
I personally feel like it would be more difficult to be an attorney, just because they have objections that are raised that maybe they've never seen before, and they have to think on their feet. And if you watch Danny, he was incorporating case law into some of his objections, and we generally know kind of the general flow of a cross-examination, and as long as we know our statements and the different exhibits, we're generally prepared for what happens.
And along the same lines, I think we find cross-examinations really fun.
Yeah,
we like to
they're
kind
really
of throw off the attorneys sometimes, keep them on their heels.
Yeah.
Well, and the inverse to that, do you ever get mad? Were you ever angry at any of the questions that defense was asking you?
No, I mean, I feel like as a freshman, kids who come into mock trial and aren't really familiar with it, you're more likely to kind of go to their level, I guess, and just kind of shout back and fire back. But yeah, I mean, we've gotten to the point where we just kind of let it roll off our backs.
Right, and you realize which questions are more important, which ones you should fight on, and which ones you have to say yes, you're correct.
Yeah.
Now, it did seem that this year that was a lot more, and maybe this was just because this is fresh in my mind, but it seemed a lot more that on both sides the witnesses were getting cut off. The attorneys were really on it, like a real courtroom. Did you feel like, compared to being the soccer player versus the...
I feel like this year they've been doing that a lot more. I think it's good, for an attorney to do that, definitely.
I think it's also because last year there were more students testifying, and this year 3 of the 4 witnesses were adults, so they had to have more control and make sure they could be a little more aggressive.
Now, do you try out? So you wanted to be you're a history teacher, right?
Yes.
Yeah. So did you say? How does the team decide which role you're going to play? Or?
We just kind of. It's kind of a collective decision. We go through, try out different roles, and it's really whatever suits each person the best.
Okay. Well, thank you both very much. I think
Thank
we're
you
about
very
ready
much.
here. And
Yeah.
good luck with everything.
Thank you.
We're going to join the deliberations on the floor right now.
You may be seated. We'd like to offer maybe a few comments here before we proceed with the awards. Just my comments would be that I thought it was an outstanding performance from both sides and from all participants. It really was very enjoyable to watch. It was a very vigorous trial. Everybody seemed to be well informed about their roles and the facts, and I just thought you did a wonderful job. So we've got some other comments.
Yeah, I'm just going to go through a couple of my impressions and try to make it as brief as possible, because I know you've been here 3 days doing this, and you don't want to hear us a long time. In terms of the themes of the case, I thought you did an excellent job carrying forward your themes, starting with the plaintiff, with the home being the castle, and you finished with that. I mean, you weaved that together very well through the case. Emphasis on chilling effect. I've heard a number of trials the last few days, just as you've been trying cases, but I didn't get that same emphasis in some of the other cases, and I think that's really a good point to make. I mean, this is a First Amendment case. There's probably no more important point than the chilling effect. And toward that end, you minimized what Alex did, talking about it being venting disagreement, trying to take control of his education. I thought those were all good points. Defense also did make a good argument with your theme. I mean, the strongest argument, it seems, for the defense is, yes, the blog was done at home, but the conduct reached into the school by the invitation to the students to do what they did. And I thought you did a good job of carrying that through the case. There were a couple issues on experts where I'm not sure I would have conceded that the scope of the expertise. One related to, and this I've heard a couple times, but the IT expert being an expert on data retrieval, that may have gone a little bit farther than what you needed to concede. The other one, which was probably more important, was conceding that Dana Clark was an expert on conflict resolution. I don't think you needed to make that concession, and that gave Ms. Clark, I think it was Ms. Clark, yeah, a chance to provide a lot of opinions that otherwise she would probably not have been able to do. Objections, it seems like during the years I've been doing this, one of the common themes, and it's a common theme in real practice too, in terms of what do you do with a witness who you can't rein in? And I don't necessarily have any great answers. I mean, I think you, as an attorney, you want to point out that the attorney is not being responsive, but by the same token, you don't want to get bogged down with objections to the point where it becomes distracting to the trier of fact. And I can tell you, just from a trial judge's perspective, on the second witness, or the first witness on the defense, it became very distracting to me, the number of objections that were made. In other words, in following the witness's testimony. And ultimately, if you're going to persuading us, you want us to follow the answers that you're getting from the witness. Invention of facts probably got a little bit, probably too many objections on that also on the last witness, the IT expert, except Mr. Strunk, I thought you did an excellent job of pointing out the limitations on his testimony, which were you didn't have, he couldn't testify to the number of persons who accessed the blog, and he couldn't testify to how many minutes for each person, and I think those were really key points to make. So witnesses did a great job, and just across the board. Witnesses, what I look for, there's a lot of theater that goes into a witness, but the witness that is the most believable to me is someone who comes across very simply, responds very simply. Some of the witnesses it's harder to do that with, like Alex, but the more you can adhere to that and come across as genuine as the person that you're portraying, I think it just comes across better. And those would be all my comments.
I work for the ACLU. I've worked there since 1995, except for a few years when I didn't. I was working for the ACLU when the internet came around. I was working for the ACLU when Columbine happened. So I have lived and breathed these actual cases, and so it was a very fun case to watch. And I promise you, I came into this totally objectively, even though I always come in on the plaintiff side in real life. For me, what the case was about really hinged on can defendants show that this was such a material and substantial disruption within the classroom that there was no other choice but to discipline the student. So when you see my final scores, that's what this is based on. Now, I thought that as far as your overall courtroom decorum, your mastery of the rules and the regulations within mock trial, very good on all sides. You guys do a fantastic job speaking extemporaneously, thinking on your feet. With your objections, I agree maybe there was some objections in there that they didn't need to be so frequent or forceful, because then I think you start to lose sight of this case. And this is not a hard case at its core, as far as I see it. Is this one side has to hammer away at, look, doesn't matter what the speech is. It was done off school grounds, not using a school computer. That's what they need to hammer away at, and that's what they did. You guys at the same time need to show that there was substantial disruption. I thought when you started off doing that with the opening statements, you set it up perfectly, but I thought you lost sight of it a little bit throughout the case. And then, but again, I think they had a slightly easier case to make on just, this is speech, you can't touch it. But I can be sold on the idea that a material disruption is so great that there's no choice but to discipline the student. And in this particular case here, not all of the cases that I've seen in real life. Kind of as an aside, I would have liked to have seen plaintiff's side emphasize a little bit more, or even get into a discussion of what type of control anybody might have over third-party speech that's viewed by students within a school environment, and whether a school can do anything about that. That is taking the student out of almost the student context and saying, hey, look, if something is disrupted in a classroom because of what students are looking at, that's really no fault of the person who's posting the information online. The person posting the information online can't control what students are doing, although there was a lot of, in the very beginning, some good back and forth about exactly how disruptive the student was being, and I thought that was very well done by defendant's side in the very beginning there. But I think that the case itself was set up very well to be very balanced on both sides. So my compliments to the people who put this together for mock trial, because when I first started looking at it, I said, well, this is, with my own personal biases, I can take a look at this and say, well, I mean, just, and aren't I going to be knee-jerk on behalf of the plaintiffs here? But I thought the defendant's case and the way that you guys handled it was well done, showing that, again, the level of disruption, I do think it could have gone even further, though, with the showing the amount of disruption that there was and that there could have been with regards to students in the future. So, again, I think it was just very well done on both sides. You guys did a great job. And please take this all as sort of advanced commentary as to what you're doing, where we're treating you. You don't need to hear again how well you did, how you're going to be good lawyers in the future if that's what you decide to do. We're judging you, like you're real lawyers here, and I think that's the ultimate compliment.
I couldn't agree more. And as a practicing attorney who tries a lot of cases, I was extremely impressed by all four of you and by the witnesses. I thought that you made very good and concise opening statements. You told us what to expect, and you delivered on it in your closings. So I thought that you pulled it together, and that's something we don't always have the ability to do. I thought you responded well, given the fact that you had 2 minutes to pull together your closing comments. And I know that you were, a lot of it was already pre-scripted, but you did a nice job, especially Mr. Dupuy, of responding to their a person's home is his castle comment. I thought you did a nice job with that. I thought that you also, Mr. Dupuy, did a very good job controlling Alex on cross. You had some witnesses, and I certainly know this from experience, are very hard to control. And I thought that the way you handled your questioning of her was extremely good. It's tough to do that, and I give you a lot of credit for it. I thought that all of you did a very nice job on your direct examinations, and I thought that you let the witnesses tell the story as opposed to you telling the story, and that's what a good trial lawyer does with his or her own witness. It's, again, not easy to do, but I thought you did a great job of that. I thought that, Ms. Schwab, that on your cross-examination, you used facts very well with respect to the web, the blog, and you got the professor at a place where she had to concede. And the facts in this case are so tightly scripted, it's tough to do, and I thought you did a nice job with that. All across, I think you all have tremendous qualities. You've learned an awful lot, and I hope that you use the poise and the intellect, the ability to speak on your feet and to think things through and make connections like you have through the rest of your high school and college and hopefully law school careers. So I want to congratulate all of you on a wonderful, wonderful presentation.
I would just echo some of the comments of my colleagues. I thought you all did an absolutely terrific, fantastic, wonderful job here. This is a difficult competition. It's tough to judge because you all do such a great job. I thought the level of preparation was outstanding. You all knew this case inside out. I thought the presentations you all made were very polished and persuasive in many different respects. I thought the opening and closing statements were especially good across the board, and all the witnesses did a very good job sticking to the facts and letting those facts speak for themselves throughout the questioning. So I just want to congratulate you on a job extremely well done.
Well, I likewise want to congratulate everybody on a terrific job. I thought this was just a fantastic trial. I think I awarded some of the highest scores I ever have in a trial for this one. I'll comment just very briefly on a number of things I really liked that both teams did. I liked the fact that all the witnesses were true to character and true to the characters as written. I've seen some of the characters portrayed just unbelievably given the way they were written. I've seen Alex Leslie portrayed as so sweet that I couldn't conceive of her, using profanity on the blog the way she did. And likewise with Professor Lee, I've seen that played a little bit. I just thought that untrue to character, and I think, in my eyes, that was very well done. With the Alex Leslie character, I agree. I thought your cross-examination of her was really good. You did control her. On the other hand, I really like the fact that you conceded what really ought to be conceded. I think you don't have to, fight with every question posed to you, and you just concede what ought to be, and that actually worked well for me. I like the fact that everybody had themes that they stayed true to throughout the trial. I really like the fact that plaintiff's team kept it simple. There's only one issue in this case, whether my client's First Amendment rights were abridged. Simple works for me, so I thought that was really well done. And likewise, the home is my castle theme. What was nice, and you folks talked about. I forget how you put it. You said something like this was. Well, I forget. I'm sorry exactly how you posed your theme. I don't have my case notes right in front of me, but I thought that was likewise well done. And the other thing I thought everyone did that took it to a new level for me is the way you worked off each other. This team was always saying you were listening, and then you'd write it down, and I'd say, I wrote this down. I'm quoting here. That was powerful. And Mr. Dupuis, the way you worked off their closing and the home is my castle thing, beautiful. I just thought it was incredible how you guys were all actually listening. It wasn't merely scripted. You really listened to each other and did a sensational job. So congratulations.
The level of mastery of the rules, both the evidentiary rules and the competition rules by the attorneys, was just nothing short of phenomenal at this round. And then for the witnesses, your knowledge of the details of the evidence was also phenomenal. Just a couple of points in that initial examination of Alex Leslie. There was a wonderful bit of theater there, and you were very much in character and very sympathetic. But that piece of teamwork where Danny asks you, well, which note got you into trouble? And you said, well, I don't know. That's the whole point. That was wonderfully done. That's the good news. The bad news is that I think I heard you, in attempting to diminish the significance of the obscenity and so forth, saying, I never believed anyone would see it. And I was waiting for you, Mr. Dupuis, to walk all over that one. It's in a blog, but you kind of got away with that if I heard it correctly. And then in Mr. Manson, your examination, having assiduously distanced yourself from any notion of statistics, of course, you then managed to blurt out that that the principal relied upon my statistics, and I could sense Danny getting ready to strike like a cobra. But to your credit, you did an admirable job of digging out from under that little bit of problem that you created for yourself. And then I, too, was impressed. I'm always impressed in argument to the extent to which the attorneys respond to the other side's points or themes. So I, too, was impressed, Mr. Dupuy, by you took their home as a castle theme, and you did the best you could to storm the castle and breach the walls and show that with the internet, it's not that simple. And Mr. Strunk, you specifically responded in rebuttal, understanding what rebuttal is, to the cases cited to show how they weren't really applicable, and that was well done.
And are there any parents here? I know there's parents listening. Teachers, which are the two of the teachers over here, and legal advisors. For you here in this room and those all who participated, we want to thank the parents and the teachers and the legal advisors for your encouragement, for the time, the extra effort that you have given these students the opportunity to have this experience and to learn about our legal system, because without you, the students really wouldn't be here. And to the students, that you really taken up this opportunity and made the most of it. And I think we're all very proud of the job that you've done and that your students here in Ohio. So with all of that, procedurally, I'm going to come down front and I'll present the Outstanding Witness and Outstanding Attorney Award, and then the judging colleagues will join me and we will announce the winners. The Outstanding Witness Award goes to Hannah Kahn. You are more graceful than I am. And the Outstanding Attorney Award goes to Danny Strunk.
Good afternoon, everyone. My name is Addie Natalie, and I'm the high school mock trial coordinator for the Ohio Center for Law-Related Education. Before we announce our first and second place teams, I would like to take a moment to recognize all our students and team and legal advisors here. But I also want to thank our sponsors. The Ohio Center for Law-Related Education is fortunate enough to have several sponsors, and they were represented on our judging panel today. They include the Supreme Court of Ohio, the ACLU of Ohio Foundation, the Ohio State Bar Association, the Office of the Ohio Attorney General, and mock trial is also made possible with a grant from the Ohio State Bar Foundation. So please go ahead and help me thank all of our sponsors who make the center possible. I would also like to go ahead and call up our team from Indian Hill. I'd like to introduce you to their team advisor, Steve Rieger, who's going to help me introduce his fellow advisors and team members.
Thank you, Addie.
Quickly, just to introduce the team, we'll start with the team members themselves. We'll start with our timekeeper and bailiff today, Rigby Wilkins. And our witnesses, Alex Leslie, played by Hannah Kahn. And Dana Clark, played by Olivia Morris. Our two attorneys, Brittany Schwab and Danny Strunk. And I'll call up our two legal advisors. We have a fantastic division of labor at Indian Hill. They do all the work, and I take all the credit. Dave Prem, Chuck Reynolds.
I'd also like to take a moment to introduce our team from Sylvania, Southview. I'd like to call forward their legal advisor, Denny Lyle. Help me recognize the team.
Thank you, Addie, and thank you to the judges for their efforts today. I'd like to introduce our team. It is comprised of Kevin Cavanaugh, who was our bailiff today, but also our witness during the course of the competition. Austin Mance, who played Kendall Dell. Brianna Cry, who played Professor Lee. And our competing attorneys this year were Smriti Gupta, and our other final attorney is Clement Dupuis. And the last person to be added to this is the matriarch of the team, my wife, Vicki.
Are we ready? All right. The 2010 Ohio Mock Trial Competition runner-up is Sylvania. And the 2010 Ohio Mock Trial Competition winner is Indian Hill.
thank you again to our judging panel and our students. We're so appreciative of your time and hard work and dedication, and we hope to see you again next year.
You've been watching the Ohio Channel's coverage of the Ohio High School Mock Trial Championship competition. Once again, congratulations to the winning team, Indian Hill High School. They will head to the national championships in Philadelphia, Pennsylvania. To purchase copies of this program or to view it free online, visit us on the web at ohiochannel.org, where you can also view live and past video coverage of your Ohio government, including the Supreme Court of Ohio. For all of us here at the Ohio Channel, I'm Dan Schellenbarger, and thank you for watching.